Yes.
Please, your Lordship. Lordship, I would like to mention item number 31 with the consent of other side, Lordship.
Yes. RDM Azamdar, learned counsel for the appellant with consent from the other side. Press for listening the matter after
Next week, Lordship, on Wednesday or
Wednesday. Possible? Okay.
On 6th.
highly obliged.
May I please allow it? The first appeal, it may be listed for admission, Your Lordship. Last listed on April, Your Lordship.
When do you want?
On 5th, Your Lordship. Admission, not on 5th. On 8th. 8th. Okay.
My pleasure, Lordship. I'd like to mention item number 4 of today's shift, Lordship. I seek an adjournment for today, Lordship, since we are trying to settle this matter, Lordship. We need at least 2 weeks time, Lordship.
Mr. PJ Burman, learned counsel for the petitioner. Press for listing the matter after 2 weeks.
Highly
There,
okay.
Lord.
Highly okay.
Yes.
May please, Lord. I'd like for listing of a substitution application for Monday, Your Lordship.
Next Monday.
Good. And I have a similar prayer where Your Lordship has dismissed my CRPIO and gave a liberty to file an arbitration appeal. That may be listed on 6th of November. Highly obliged.
May I please, your Lordship, I want to mention regarding listing of a MAC appeal on Monday for orders, Lordship. It was last listed in November of 2021. Much obliged.
May it please your Lordship. Lordship, I beg to mention item number 35. Lordship, this matter is a part-heard matter. Lordship, the engaged learned counsel has already argued this matter before the Honorable Justice Mr. Parthiv Soikia. So, Lordship,
35.
yes, Lordship, item 35.
Okay.
Lordship, matter may be fixed after 20
No,
November.
no, this court will not fix the date.
Your Lordship.
Rest will fix the date.
Your Lordship.
Miss, your good name?
J. Besbora,
Jay Besbora, learned counsel appearing on behalf of Mr.
DC Card Hazarika.
TC Kathazurika, learned counsel for the appellant, submits that the matter was substantially heard by by a coordinate bench of this court. And accordingly, it is right that the matter may be listed before the aforementioned court. It is provided that rest shall list the matter before appropriate bench. Okay.
Obliged.
Please, Lord. But my prayer is for listing a contempt petition, Lord. If this contempt petition is also related to a MSc appeal, the contemptor violate the judgment passed by this honorable court and have not released the enhanced amount. That's why I'm preparing for listing it. On
Okay.
next week, Lordship.
Okay.
On 13th. Obliged.
May it please your Lordship, I am praying for listing of the matter for order.
Which matter?
It is regarding condonation of delay in filing the application for substituting of the
When,
legal hire.
when do you want?
Sir, Lordship, whatever you may say.
Okay.
On 8th November.
Your Lordship. May I please, your Lordship? Lordship, I beg to mention for listing of IA for order for disposal.
When?
Your Lordship, may can you fix the matter on 6th November?
6.
Okay.
May I please your Lordship. I beg to mention for listing a MSc appeal on 2nd week of November. Orders.
For
Orders.
orders. On 13th November.
May I please your Lordship. Lordship, I beg to mention for listing of CRPI on Monday, Lordship, for orders. Oh, yes.
Please your Lordship. Lordship, I beg to mention item number 15 of the daily list, my lord. My lord, the engaged senior counsel is unwell today. So my lord will be pleased to take up the matter on Monday, ma'am.
15.
15, item number 15, my lord. This has come for the first time before this honorable court. Lordship may please to fix the matter on Monday.
Your good name?
I am P. Das appearing on behalf of Escalita.
Mr. P. Das, learned counsel appearing on behalf of Mr. Sadhan Kolita, learned counsel for the appellant. Press for listing the matter when?
Monday, madam.
Next Monday?
On sixth Monday, we have already given so many dates for Monday. On sixth, Wednesday.
Wednesday. Obliged.
Item for motion, item numbers 1 to 3.
My lord, in this matter, since the petition for transfer that has already been transferred, I will seek liberty to withdraw that particular transfer petition so that the main matters can be listed. It can be argued today or any other day.
Okay. Mr. Ken Balagopal, learned
My lord,
advocate general.
Lordship kindly hear us. My lord, the impression has been given as if the transfer petition has become infractious because the Honorable Chief Justice has transferred it here.
He has already
Honorable
passed
Chief
an
Justice.
order in administrative side.
My lord, that administrative side, my lord, it cannot supersede section 24 of CPC, and we have a right to see that order, my lord. We'll have
It's
to see.
available in the record.
You can see
My lord,
that
in the record, last time we did not find.
No, it
Then-
is available in the record.
it was there.
My lord, last time we did not find how.
No, it is available.
My lord, then we can check it up. Your
Ah.
lordship can hear this petition, it is in the board.
It is there.
Oh.
So therefore, we have a right to argue this case. Well, it is not automatic transfer.
How
No. He want to withdraw the
Transfer-
petition
Then if it is
as the
withdrawn,
matter become infractious in view of the order passed by the Chief Justice in administrative side.
no, what I am saying,
Yes,
if the transfer petition is withdrawn,
yes.
how come these other cases here?
Which cases?
the transfer
The civil division petition cannot be
Those
here.
are transferred by Chief Justice
Lord, we shall have to
in
see that.
administrative order.
It cannot be an automatic transfer.
No, you see the record, sir.
We shall see that.
You see the
That
record.
will be dangerous precedent because the judges over there, that means they are not trustworthy. We cannot rely on them.
In fact, my lord,
It's a dangerous
No,
proposition.
no.
What has appeals court has said, I will take your lordship to there.
No.
If it is so easy, tomorrow I will file an application.
Mm.
My lord, the ground of the transfer petition is that White's adjournment was granted.
Mm.
That's the reason we cannot rely on this particular judge.
Mm.
And it's a slur on the judiciary as well
never
as the bar.
said any word against any judge. Please don't.
You see,
don't put words
you
in your
please,
mouth.
when I am on legs,
Yes,
don't
but
utter
don't
anything.
speak wrong
Don't
things
come in
about the
between.
judge. You have no business
You
to
don't
talk.
come, that's
No
the
business
reason,
to
that's
talk
the
about
reason
it.
your lordship is required to hear it. Because what imputation has been made?
No. If the petitioner want to withdraw the petition, where is the question of hearing?
No, if it
Why,
is
why,
withdrawn,
why
then
the
how-
court spare the time?
no, in that case, how your lordship will hear the civil division petition?
That has already been transferred by the Chief Justice in administrative side. You see the order.
Well, we shall see the order
see the
and
order.
we shall.
Let us go through this record. Lordship will take it up after some time. Let us.
Yes, you can go through
Please
record.
just let-
Ah.
Because after going through this note, what I could find is, my lord, 3 prayers were laid before the Honorable Chief Justice.
Yes,
Now, one prayer was transfer petition, and perhaps these CRP 1 and 2 were connected with the transfer petition. So I don't know how it has been, note has been placed. It has as if it were a linked case, because in
Mm.
this case also your lordship will see they have written as linked case. So transfer petition. Now, my lord will kindly appreciate if the Honorable Chief Justice has transferred the transfer petition on an administrative side.
no, transfer petition,
Let's see.
Let-
Well, we
let-
shall
let-
see the record then.
we-
we should
you
please
see the note,
after-
yes. It- और बाकी ये रिकॉर्ड की तरह से हाँ? Taken it.
We'll just go through.
No, you can go through it.
Yes, sir.
We'll take it
After
after
number-
some time.
After.
After some time.
At number 5. At number 5.
My MSc case is dismissed, Lordship, for evidence of this police officer. I have not examined the police officer. Just it has also been filed, Lordship. And I will examine 2 witnesses. And only for non-examination of the police officer to prove the contents of the charge sheet or police documents, it is dismissed, Lordship. So it may kindly remanded back and there is no delay. And after 3 days only, the FIR was lodged, Lordship. And the cause of delay is also mentioned there in the FIR, Lordship. For they were busy in doing the works of the deceased, Lordship.
No, this is against the judgment passed by the learned member MSCT.
Yes, Lordship.
So you have to prefer an appeal or revision petition.
Revision petition appeared because this is dismissal case, Lordship, and the case is already proved, Lordship. I
No,
examined.
where it is provided that in the event of dismissal of an MSC claim petition, you have to prefer civil revision petition.
Lordship,
This is against the judgment. You have to prefer an appeal.
this is judgment come order, Lordship, only after proving everything, Lordship, only for
No, that's all right.
non-exams of the police officer, Lordship. Only.
No.
And simply this case may kindly be remanded back to.
No. You have to prefer an appeal. This a revision petition against the judgment will not lie. You see, you examine the matter whether it is maintainable or not.
Again, dismissal only, Lordship.
Where it is provided, if the claim petition is dismissed, then revision has to be preferred.
No, Lordship, of course.
You-
And Golab,
You examine the matter, we'll take it about 2 o'clock.
Five. Sorry, item number 6.
My lord,
Yes.
the impugn order is at page 41. Everything began with annexure 1, your lordship. If your lordship kindly comes to annexure 1. Annexure 1 in vernacular starts at page 19, your lordship. The case is the petitioner is are running of 2 bills by cultivating fishery, my lord, since the year 2009. Now, out of a blue, respondents file an FIR, which is at page 19, my lord. The grounds in the FIR is misappropriation of money, misappropriation of bill. And
Where is the impugn order?
impugn order, your lordship will find at page 41. Observation, your lordship will see
Page number 40.
41.
So this order was passed in a proceeding under section 107 and 145 CRPC. How this CRP is maintainable?
My lord, CRP is maintainable because I have filed under article 227 and read with 115 of CPC, my lord.
No, this you can file appeal before the learned session judge.
One option. Secondly, criminal revision. And your lordship, when there is a irregularity, we can approach under article 227 also.
Are you sure?
Yes, my lord. Otherwise, registry would not have passed this matter before your lordship.
No, merely because the registry has passed the matter and list the matter before this court, it does not mean that this court has the jurisdiction to entertain this application.
My lord will kindly see irregularities, why I am under article 2.
No, whether we can examine the matter in exercising article 227 or not, that is the
lord,
question.
In my respectful submission, yes, your lordship.
You show the relevant provision.
provisions to the law. Article 227 is a supervision power, madam.
That's
Your
that's
lordship.
all right. There is no dispute about it. And when alternative remedy is available, this 227 petition does not lie.
The supervision.
কবে
Procedural.
গভর্নমেন্টের কোন আছে
My lord, you kindly see the irregularities.
No, no.
Whether your lordship will.
We'll say, we ask the government advocate Assam to appear here in this petition. We'll take it up after some time. You will inform the government advocate.
Item number 7,
Hello, the government advocate.
Can you please call Mr. D. Nuts? Call him.
item 7.
Yes.
The last occasion, Lord, the court has directed me to submit a partnership deed, Lordship. I also submitted, Lordship, according to affidavit. But the question is that it is the matter of a farm, Lordship. Those who filed the money suit against me, he is not the partner of that farm, Lord. So this claim is not entertained, Lordship. According to Partnership Act, Lordship, Section 4, Lordship. Sorry, Lordship, 69, 2, Lordship, subsection 2. No suit to enforce a right arising from the
8 minutes. Section?
69, Lordship,
Yes.
subsection 2, Lordship.
Yes.
No suit to enforce a right arising from a contract shall be instituted in any court by or on behalf of a firm against any third party unless the firm is registered and the person suing are or have been shown in the registered firm as partner in the firm. But in this case, Chandan Korika is not the partner of that firm. A partnership deed, Lordship, kindly see in affidavit, Lordship,
Where is the impugn order here?
Model, Lordship, page 24, Lordship.
24.
I filed a plain petition, Lordship, under order 7, rule 11, CPC, Lordship, to dismiss the plain, Lordship.
Okay, let notice go at this instance. Let the other side enter appearance. After hearing, we will consider.
State the proceeding, Lordship. I cannot continue, Lordship, without wrong process, Lordship.
Okay, till the appearance of other side, we will state the proceeding.
Lordship.
Where is the partnership deed?
Lordship, in affidavit, Lordship, I filed page 38 and page 30 to 37. Page 30, Lordship. Their name is there. Krishna Murari, Sandeep Bajaj, Sumit Bajaj, Sangeeta Bajaj, Simple Bajaj, Sumit Bajaj. I'm sorry. Where Chandan Kolita is not there.
Chandan Kolita is?
Kolita is he filed the case against me, Lordship. He is a third party, Lordship. According to law, he cannot entertain, Lordship. He has no power to file any suit against him. In the plaint, Lordship, it is written just represented by one of his employees, Sri Chandan Kolita. This type of case cannot be represented anybody, Lordship. Any of the partner can file, no third party.
And where is the plaint?
Plaintiff page in main petition, plaint 10, Lordship, Excel A, page 10. Suresh Enterprise, a partnership firm registered under Indian Partnership Act 1932, having its principal place of business in Dawanpatti, Fancy
Okay,
Bazar, Guwahati, District Kamrup, Assam, represented by one of the employees, Sri Chandan Kolita. It is the fact, Lordship. Technically, it cannot entertain. So I have cleared all the balance, Lordship. I return whatever is existing the materials in my shop, I also return it.
Heard Mr. A. H. Alamgir, learned counsel for the petitioner. Person to order dated 30/9/2024, Mr. Alamgir has produced the partnership deed before this court by filing an additional affidavit. Where is the deed? The contention of Mr. Alamgir is that in view of subsection 2 to section 69 of the Indian Partnership Act, no suit for enforcement of a right arising from a contract shall be instituted in any court or on behalf of a firm against any third party unless the firm is registered and the person suing are or have been shown in the register of the firm as partner in the firm. Referring to the said partnership deed produced before the court, Mr. Alamgir submits that the suit was instituted by one Chandan Kolita, who is a third party, and as such, the suit is not maintainable in the eye of law, and therefore, Mr. Alamgir contended to stay the aforementioned proceeding pending before the court of learned. Where it is pending? Civil Judge,
eh,
Junior Division, Kamrup,
Union,
M. Having heard the submission of Mr. Alamgir, learned counsel for the petitioner, I have carefully gone through the petition and the documents placed on record and also perused the relevant provision of law. And I find force in the submission of Mr. Alamgir, learned counsel for the petition. However, at this stage, notice be issued to the respondents, returnable in 4 weeks, that be taken by registered post with AD and also by usual process, with any week from today. And in view of the submission of learned counsel for the petitioner, and in view of the relevant provision of law, this court is of the view that a prima facie case is made out for staying the proceeding pending before the Court of Learned Civil Judge Junior Division, Kamrup M at Guwahati. Accordingly, further proceeding of title suit number, money suit number so and so stands state till returnable date. List of the forwards.
Item number 8.
Next.
May I please, Your Lordship, in this case, I am called sole responsible. We have filed Ukalapma yesterday itself. Let the matter may come in the next week, and in the meantime, petitioner may be directed to furnish a copy of the CRP.
Okay, heard Mr. B. Kosek, learned counsel for the petitioner, and Ms. Roy, learned counsel for the sole respondent. This application under Article 227 of the Constitution of India, the petitioners have challenged the order, correctness or otherwise of the order dated 5/8/2024, passed by the learned district judge Dibrugarh in title suit number 2 of 2023. Is to be noted here that by impugn order dated so and so, the learned district judge Dibrugarh has allowed the petition number 1837 of 2024, dated 21/5/2024, filed by the plaintiff for issuing notice to the opposite parties and other third parties to submit original documents. How, Mr. Kosek, how you are aggrieved?
Malad, if your lordship finds the first order of 21/5/2024, where there was an objection raised by us during the cross-examination that the documents which they have produced without any leave, and there are certain documents which were never a part of the plaintiff. And as per Order 7, Rule 14, Malad, if they have to produce any document under 14 clause 3, Malad, their leave has to be taken. They have exhibited those documents, and they are done it. District judge allowed our petition. And in the contrary, again passed this order of 5/8/2024, which amounts to review of the earlier order. And apart from that, Malad, the petition which they have filed, it was without any affidavit, without any verification. That petition itself was not maintainable. After the hearing was concluded, on the date of the order, the counsel for the plaintiff filed an application allowing him to file the affidavit and verification, and the Honorable Court allowed it.
Petitioner is contesting the case in person, Milan. He does not know the law. Let
That
the
is
matter
not
may come in the
observed.
next week because I have no copy.
Yes, okay. Let notice be issued to the respondent. Returnable in when?
Next week, any date. Milan.
Can it be on 7?
Okay.
7th, not on
8,
on 13th or 11th, on 11th.
11.
11.
Wait.
However, no formal notice is required to be issued since Ms. S. Roy, learned counsel for the respondent, entered appearance and received notice. However, extra requisite copy of the to her during the course of the day. Place the matter on.
For motion.
Huh? Mr. Kosek, have you filed Ukalatnama here?
Well, I'm representing Mr. on behalf of A. Sharma Madam. I'll get an Wakalatnama meeting.
Okay.
Item 9.
May I please, Your Lordship.
Yes.
Respondent of the decree holder, my lord. They put the decree in execution. The petitioner has filed their objection in terms of section 47 of CPC, and the other side has filed their objection. Till that petition is decided, my lord, the petitioners filed another application for stay of the execution proceeding in view of another TS was pending. So that was rejected. Thereafter, petitioner came before this honorable court, and that was also rejected. And while disposing of the CRP, my lord, direction was to appear the parties there on 25th of May 2024. But 25th of May 24 was a holiday. That is why they have appeared on the very next opening day, that is on 27/5/2024. On that day, learned court below has found that no objection has been raised, so he ordered for issuing of writ of the decree. That is that thereafter the petitioner filed a review that was also rejected. Against that I have come. If your lordship come to page 23. Page 23. This is, my lord, the order passed by this honorable court in CRP. And relevant portion is at page 27. Paragraph 12, my lord. Consequently, the instant petition is still dismissed, thereby directing the learned executing court to proceed with the decree in accordance with law. Taking into account that the parties are duly represented, this court vacates the interim order dated 18/11/22 passed by this court and directs the parties to appear before the learned executing court on 25/5/2024 in connection with further proceeding with the title execution case number so and so. The instant revision petition is then disposed. Now, my lord, thereafter they have appeared since 25th was a holiday, they appeared on 27th. That is at page 29. That order is at page 29. And Miller 11 portion is at page 31, Miller. That had the learned counsel of the decree holder. The learned counsel for the judgment debtor was not present today, although the judgment debtor was present in person today before this court. In view of order passed by the Honorable Guwahati High Court and judgment debtor not raising any objection, I deem it fit to direct to issue writ after proper verification. Whereas, my lord, objection has been filed and that was not decided at all, my lord. This was the mistake. So, in terms of section 152, the petitioner has filed an application to amend the order. That is at page, my lord, 33. And that was, my lord, rejected by the order dated 1/24, my lord. At page 36, my lord. Where did, my lord, that order?
Yes.
Both parties are represented by their learned counsel. Today was the hearing for petition number so and so, so and so. There is judgment debtor sought to review of the order dated so and so passed by this honorable court on the following grounds. One, my lord, that is not the 3. Next page, my lord. Ground number 3. That the preliminary objection dated so and so and final objection dated so and so are yet to be heard and disposed of before proceeding with the execution of the decree. This was the main ground, my lord. But learned court below has dismissed this application on the ground that there is no prima facie error, my lord, on the face of the report. But
Yes, that is the requirement.
Yes, my lord, but that was in terms of section 152. Although this was written as review, we have section 152. There is an omission on the part of the learned trial court, my lord. Because an objection was filed, that was still pending, but learned court has found that no objection has been raised. That is why we went to the stage of issuing writ. If your lordship come to CPC was section 152, my lord. Where,
Here, where is the petition?
4 below.
Where is the petition?
Objection, petition.
Yes.
Yes, my lord. At page 15 below,
1-5.
1-5.
Where is that observation that no objection was filed?
Yes, my lord. That I have read already. At page below 31. Page 31. Had the learned counsel for a degree holder, the learned counsel for a judgment debtor was not present today, although the judgment debtor was present in person today before the court. In view of the order passed by the Honorable Guwahati High Court, the judgment debtor not raising any objection, I deem it fit to direct to issue it after proper verification. That is a clear omission on the part of the trial court, my lord. Whereas the order passed in the CRP was for appearance of the parties on that day.
When this objection petition was filed?
My lord, on 22, objection petition was filed. 13/5/2022.
And whether any order was passed by the learned executing court on this petition?
My lord, no, not at all, because thereafter they have filed an application for stay of the.
Then why this endorsement is there?
My lord,
EOS
that's what page, VOS,
at page number 15.
but this is still pending, my lord.
No, you show me what order has been passed, because some order has been passed, therefore it is endorsed as VOS
My lord, thereafter,
on
my lord,
13/5.
my lord, yes, kindly come to that page, my lord. At page 19. At page 19.
Yes.
They have filed their reply pursuant to that views, my lord.
You do one thing, you produce this order
Below.
dated 13/5,
My lord,
2022. And this order dated 38/6, 2022.
my lord, which order?
It's two order, 13/5, 2022
13/5/2022.
and 38/6, 2022.
That I can show your lordship after some time, my lord, because I am having those documents.
You file this by way of an affidavit then.
Otherwise, I have the certified copies, my lord.
Produce it before the court by filing an affidavit. We can list it on next 4th of November. Yes.
Online.
Or Mr. Sahu, learned counsel for the petition. Justice shall list the matter on 4th of November, so as to enable Mr. Sahu to produce before this court an order passed by the learned executing court on 38/5/2022 and 38/6/2022. No, nothing. No, nothing.
Timing,
Not heard of material first.
timing number 5. Timing number 5, 6.
Mr. Nath, we want your assistance in this petition. This civil revision petition is directed against one order passed under section 107 and 145 CRPC by an executive magistrate. So whether this civil revision petition is maintainable under Article 227 of Constitution of India.
The CRPC provision the proceeding of the January. It's a criminal proceeding.
Criminal proceeding. His contention is that it is against an order and some irregularity is committed in passing the order. Therefore, this court has supervisory jurisdiction under Article 227.
Perimeter provision is there under 482. Inherent power of the honorable court is there. The supervisory power
No,
under
against an order passed under section 145 CRPC and appeal lies before the session. You please go to the
I'll go through the papers.
My lord,
Give me some time.
I'm across with a judgment of Gujarat High Court. 1970, 11th Gujarat Law Report, page 22, paragraph 5, your lordship will see. And in that case, matter was not only interfered.
okay. Let Mr. Nath go to the record
My lord, let it come up on Monday in that case. my lord.
next Monday.
Yes, 4th of November.
Okay. Pardon, sir. Your good name, please.
H does.
Learned counsel for that. This civil revision petition is directed against the order dated
Page 41.
9/9/2024 passed by the learned executive magistrate Lakhimpur, North Lakhimpur in Miss Case number 130 of 2023. Under section 107 and 145 CRPC. In view of the issue raised in this petition, this court deemed it appropriate to seek assistance from the learned senior government advocate, Mr. D. Nath, and accordingly, Mr. D. Nath entered appearance and press for listing the matter on next Monday. Fair is accordingly allowed. Recess will list the matter on Monday.
My lord,
You furnish a copy to
My
Mr.
lord.
Nath
may I please
along
watch-
with this.
Till
judgment?
Monday, my lord, the matter may be.
No. First, we have to ascertain the jurisdiction, whether we have or not.
Pending item number 1 to 3. Lord, I have gone through the record and what I prayed this day. Lord, we maybe supplied you the copies of the administrative order because we, Lord, through my colleague, I tried to upload the registry for certified copy. They said it's not available.
Not?
So they cannot give it. So therefore, only thing if your lordship pass an order to give, and moreover, on the top of everything, your lordship will find they filed an application. On the basis of the application registry make this note, that application we did not file. I did not find in the record. So therefore, those application along with the administrative order of the Chief Justice is required for us. Would make a submission. Because we are not asking for a
basically wants an order of the Honorable Chief Justice to be reviewed by this court. Virtually, he is asking for that. Therefore, since an order has already been passed on the administrative side by the Chief Justice, all that I say is, if he has an objection for my withdrawing the petition, I would put it differently. I would say I'm not pressing that petition because it has been allowed, either way. So now this is how the matter gets protracted from day to day. Therefore,
Very easy to say,
therefore,
very easy to say.
as far as this case is concerned, since the Honorable Chief Justice has passed the order, now it is clear. Well, last time when we came, we were not very clear about the order. Now, since that is very clear, they want to do whatever, that's a separate thing altogether. This Honorable Court now, on the basis of that, may fix a date for hearing of this. She is free afterwards to move whatever application she wants, that's completely different. Now we can't wait for this anymore. Date may be fixed for the hearing as it is. You can instruct, you can get whatever you want. And as far as the power of the transfer is concerned, which they have been contesting, that it cannot be done from Kohima to the Guwahati High Court. I mean, at the instance of the Guwahati High Court. I have myself argued this case before the Supreme Court. That is the latest judgment by Justice Rishikesh Roy and Justice Divakar Datta, where they have said that if there is one high court for different states, then that principal bench can transfer the case directly to itself. But if there are two high courts for two states, neither of the states can do it, only the Supreme Court can do it. I brought the judgment also. So this is all valid law. To say that it cannot be done and this cannot be done, of course, for sake of arguments, you can say that. It's a legal procedure. Therefore, in the light of this, last time we were not clear for some reason it was adjourned. And today again, they want to do the same thing. Therefore, my lord, we should bring a finality to at least fixing a date as far as this matter is concerned. Why there should be fixed a date means, as I have mentioned before, a group of people have trespassed into government land. And it's a very serious matter. And the way the judgment has been passed requires a lot of consideration. Where the judge himself admits that in a parallel case, in a criminal case, I write two orders and then I decide which one to issue. But he has signed both the orders and both the orders came into the hands of the government. This is what they want to do. This, we're not blaming any judiciary or anything. But we feel that our district judges in Nagaland, they also deserve to be elevated because they are also very competent. But when some of these people do like this, my lord, we are at the receiving end. This is it. So this practice has to be stopped. It's not just a transfer of one case to another. It's a case of what Justice Bella had said, that this type of activities of the judges in the lower court, where they have given integrity, they have bypassed it. These are very, very serious questions. The matter will not end here. So that, therefore, why should I take one such petition, bring it here? As the Advocate General, I am concerned that judges in the district court have done like this. So this honorable court, the Chief Justice should know what is happening. This is our duty to inform. What action they take, it is theirs. So all these things clubbed together have resulted in this. So since that has been done, and it's confirmed that the Chief Justice, Honorable Chief Justice has passed the order, in the light of that order, I am only saying that so that there is no confusion, I say I will withdraw that petition as far as the transfer is concerned, because it has been allowed. And therefore, your lordship may fix the dates. That should be final. And then as he wants to inspect or do anything, he's already at liberty. There's no problem. You can move whatever application. You cannot protract it any further. Fix the date. Here, it has been transferred. That is it.
Well, we shall give a pointed reply to all the queries, but he has said. But now, only thing, my lord, my limited request to your lordships, kindly give us the application filed by them and the administrative order of the honorable.
Who is
Chief Justice.
application?
My lord, the application they have filed.
That
Before the
application is not the subject matter of this revision.
No, my lord,
petitions.
what I'm saying,
This,
on the basis
for
of
the administrative order passed by the Chief Justice, you go to the registry.
registry is no refused.
No, we cannot.
So if your
The
lordship not-
administrative order, you have to go to the registry.
But the administrative order, which your lordship, I think it's the order dated 310. We have confirmed that we are not entitled to a certified copy of that 310 order due to this note of the registry, because that is on the administrative side. And if on the judicial side, you would have got the certified copy. Now, when we are not entitled to, my lord, the certified copy,
We are praying that Lordship will give a direction, at least a copy be furnished to us so that we know. Because there are some allegations on the third paragraph or something, my lord.
No, no,
So
that
those
is not
things
the
are-
subject matter before this court.
No, no, my lord, your
Sorry,
Lordship,
sorry,
kindly
sorry,
see one thing.
sorry.
Kindly see, let it come on Monday. Let us have this paper.
No, 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 no.
I
You
think
go to
we-
the registry, we cannot direct that paper.
Your Lordship will give it.
Now registry will-
Registry will say we can't give it. Lord,
Sorry.
if your Lordship gives a
Sorry, sorry.
direction to the registry. let
No,
them
no,
furnish a
no, no,
Copy of that,
No,
of that administrative order.
no, no, no.
All right, my lord, in that case.
For
we will-
administrative order, you go to the registry.
Okay, my lord, we shall
No.
request the registry.
If they refuse to give the same, you avail whatever
Yes, yes, yes.
remedy
That is
available to you.
Lordship, kindly observe it in that order.
No, no, sorry.
No,
Mr.
regarding-
Don't insist it.
No, no, but regarding
No,
the
no, no,
closing
no.
of the registry, my lord.
No, no.
No,
We shall approach the registry, my lord. Let
Yes.
it come on Monday.
yes.
We shall make your submission.
No, my lord. Not
I'm,
at all.
I'm
Not at
requesting the honorable judge, why you are saying no?
I am making.
You are not to
objection.
pass any
No,
order.
Mr. Balagapal, please sit down.
Yes.
Let
Yes.
it come on Monday, my lord. And
Pardon?
in the meantime, we shall approach the registry.
Yes. Now, today we will permit him to withdraw this application.
My lord, it's
That's
up to
okay.
him. It's up to him.
And regarding these matters, we'll fix it that.
My lord, your lordship kindly pass any order on Monday. Let us see the papers because there are certain things, my lord, which we cannot divulge now.
Mm.
After seeing that, we shall scrutinize and then only we can, my lord, make your submission in detail. on-
No, you suggested that convenient to both the parties.
No, let it come, these matters, let it come on Monday. Whatever order, whether, my lord, my learned friend want to withdraw, it is his case, he can withdraw.
Yes.
We cannot say anything.
Mm.
But these order also, your lordship pass it on Monday.
Which order?
Withdrawal order.
No, he want to withdraw this paper today, this transfer petition today.
The question would be, my lord,
No,
if your lordship.
no, we cannot examine the administrative order
No,
passed by the
I'm
successor.
not saying to.
Then,
that.
where is the objection?
No, your lordship kindly see.
Mm.
What is the contents of the or administrative order of the honorable chief justice, your lordship kindly see.
Oh, we have
Honor-
already seen.
No, honorable chief justice say,
Mm.
transfer of the transfer case before the principal seat.
Mm.
There was no adjudication.
Mm.
So how we can say that it has been transferred already? Can the
That
section,
administrative order?
my lord, can section 24 CPC be bypassed by an
Mm.
administrative order?
Mm.
And honorable chief justice hasn't said so.
Mm.
Your lordship, if we go between the lines, honorable chief justice hasn't said, because your lordship will find.
No, that's
a-
why the records are before this court.
My lord, the
Mr.
CRP
Doctor, please appreciate one thing. There was a petition. That petition was placed before the Chief Justice. Chief Justice passed an order for transferring the revision petitions.
That is where I am, my lord, I am
Yes.
interpreting. Chief justice hasn't said,
Yes,
Chief justice hasn't interfered with it. Just it has been transferred from the Konya bench to principal seat.
yes.
That is the only import
Now
of that.
this transfer petition he want to withdraw. Let him withdraw it.
Let
Where is
us-
the bar?
Let us make your submission on
On
Monday.
what point?
My lord, after getting these papers,
Hmm.
my lord, on Monday only your lordship can hear it. There is no problem.
No,
in it.
no. There is no problem. But why should we keep this matter pending while the
Look, there
petitioner want to withdraw this?
There are so many things. my
No,
lord.
maybe.
Let us get the paper,
Hmm.
because we are arguing, the paper is with your lordships, we do not have anything here.
Hmm.
Now we want to see what petition they have filed, it is not in the record.
You go to the registry.
That's the reason I'm saying, my lord.
That petition is not the subject matter before this court.
No, my lord, we have to make our submission in terms of what application they have filed, because the joint register has given some note on the basis of his application.
Hmm.
So we have to see what he has said. And that right we have, my lord. Maybe an administrative order, but we have a right.
Yes, you
Because
have
when
the
you
right.
want to transfer a petition from one place to another, what is the reason? Only adjournment.
Hmm.
My lord, two adjournment, that is also consented. And now here, my lord, any file your lordship take,
Hmm.
at least minimum there will be 10 adjournments. What that, where your lordship send this file, where, to Kohima bench or some other?
Hmm.
So ultimately, this question will come up.
Hmm. Okay, at that
But
time
if
we
for
will
a
hear the same.
2 days adjournment, a judge cannot believe
that he's interested person. Now he has
No,
said,
no,
I am
no,
not
no.
imputing allegation against judge, but Supreme Court is saying you will have to show the bias of the judge.
No, now he want to withdraw the petition.
That is the thing, my lord. Let us see all the papers.
You see
Let
the
what they
papers?
have written in that
You
application.
see the papers?
So let it come
We
on
are,
Monday.
no, no,
so-
this not a petition we are disposing of on withdrawal.
Then in that case, my lord, your lordship kindly see the administrative order. Your lordship kindly record that, then I'll place another submission.
Hmm?
Withdrawal order, your lordship kindly record after that.
Heard Mr. Ken Balagopal, learned Advocate General, Nagaland, assisted by Ms. So learned counsel for the petitioner, and also heard Mr. S. Dr. learned senior counsel, assisted by Mr. A. Das, learned counsel for the respondent. While the petition was taken up for hearing, Mr. Balagopal, learned Advocate General, submits that he has the instruction to withdraw this petition. As in the meantime, Honorable Chief Justice in administrative side passed an order for transfer of the connected civil revision petition pending before the Kohima bench of Guwahati High Court. Having heard the submission of learned,
Lord, that's the reason I'm saying. Lord, your lordship kindly see which is the connected civil division.
these are mentioned.
It's not there. 1 of 2024 has not been transferred.
Have you gone through the order of the Chief Justice?
Yes, sir.
Then I have nothing to say. If
Lord,
you have gone through it,
Can I see once again, my lord?
for transferring of
If I read correctly. That's the reason, my lord, we wanted those papers.
Mr. Balagopal, in the pair portion of the petition, there was a pair for transferring of civil revision petition number 1 of 2024
Well,
and civil revision petition number 2 of 2024.
please,
And in the order of the Chief Justice,
please.
there is a order for transfer petition number 1 of 2024 and transfer petition criminal number 1 of 2024 and CRP number 2 of 2024,
Very good. Both are there, 1 and 2.
1 and 2.
Yes.
But in the order passed by the Chief Justice, only 2 has been mentioned, 1 has not been mentioned.
Order passed by the Chief Justice.
Yes. You see the record?
No, there are 3 numbers. For petition 1, for petition criminal.
No, since Mr. Dotto has been addressing the court, you are not supposed to address.
He is another case.
That's it.
And I will also correct that the doctor is assisted by a Biswas.
Okay.
And I am appearing in this CRP number. It has been renumbered 2, which has been renumbered as 105. My case is altogether on a different thing, and his case in the main revision, my lord. These are all together in a different footing.
Okay.
These are the reasons, my lord, we wanted those
It
papers.
is there, all 3 are there. In the petition which has shown to me, my application, top of it itself,
No, Mr. Balagapal, you go through the order. That office not.
order is in this manner. The prayer for transfer of the above TRP number 1 of 2024, criminal number 1 of 2024, and CRP number 2 of 2024. All are there.
1 is there.
That is number 1 and number 2 are the civil revision petitions. So both those petitions have been transferred. Nothing has been left out. And even my very right at the top, it is written, transfer petition 1 of 2024, CRP number 2 of 2024. Yes, sir. In prayer number 2, order is number 2, the prayer for transfer of the above transfer petition 1 of 2024 and transfer petition criminal number 2 and CRP number 2024. That is, your lordship is saying CRP number 1 is not mentioned, is it, ma'am?
But the prayer in the transfer petition number 1 is transfer of CRP number 1.
In transfer petition civil number 1 of 2024, that contains both the CRP number 1 and 2. That has been supplied. Yeah. Kindly give.
No, in the pair person it is there, but in the, I am talking about this order of the Chief Justice.
That is in the transfer petition, which has been passed, just a minute. That is prayer for transfer of 1 of 2024. Correct. Now, in 1 of 2024, both CRP number 2 and 1 are there. In our main petition. If this has to be clarified, it can be clarified. That's not a problem. If there is a doubt. I'll get it clarified. No problem.
Yes, withdrawn, my lord, I believe.
Pardon?
I'm not talking to you.
You also
I'm
need not give
the Honorable
directions.
court only.
Not give directions.
So therefore, he has withdrawn it.
No
Which one?
question.
The transfer petition.
Order has not been passed.
Then why you are giving back here?
You're trying to create a confusion here as though 1 has been left out. You
Yes.
want to see some error at this. That will be rectified. Now you want to say you have done, you can't do anything. Is this advocacy?
No, you are to teach
So, my
us.
lord, if there is a confusion, we will
What
clarify.
you are doing, we also know it.
We will,
Don't try to teach us.
yes, I
Don't
know.
teach us advocacy.
Yeah, I know what has been
Try to be
happening.
within limitation.
That a judge
Don't use
passes
nasty
two
language in the
orders
court.
on the same day, he passes two orders on one application. One rejecting the bail.
He did all
and
this
the
thing
other
in the
one
Kohima
granting the
bench.
bail.
And started here
And
again.
then he says, this is how I pass orders. So if this requires clarification, we'll do it.
Then let us take it up on Monday then.
Monday.
Monday?
Monday is what date, my lord? 4th?
Yes.
Would it be on? If it's all right.
Yes. All right. For the pair being made by Mr. A.K. Balagopal, K.N. Balagopal, learned counsel for the petitioner, raises the matter on Monday. No, Tuesday, 5th of November. Next matter.
Matter number 10, part of matter for admission.
We'll get this clarified. I'll get this clarified. No place.
Wait, please. Okay, this is regarding that admission is arranged. The petitioner has in the meantime been admitted in, he's attended the
Admitted?
class also.
Okay. Where is Mr. Gupta?
He was here, but probably,
So the matter become infractions?
yes, probably it may be closed in that room. I don't-
Yes. Okay.
If his presence is required, my lord, matter will be taken up after some time, my lord. He was
Yes,
here,
let
my
him
lord.
come, yes.
Yes, but I will inform you.
So when he was admitted?
No, he reported as per last order on 23rd, he reported there, and on 24th of October, the formalities are completed.
Acha.
And he has inducted to the hostel also, and he's attending class as I am instructed.
I mean,
After some time.
item 11,
May I please, your lordship? Last occasion, we have served the copies of our appeal to both the government side and as well as to the respondent side. So here, your lordship, it's a matter regarding a common judgment and award dated 28/11/2023. It's an appeal under section 54 of the Land Acquisition Act, your lordship. So here, the matter was that the railway was not being made party. Lordship, I mentioned I am appearing for Mrs. U. Chakraborty, my learned senior advocate in this matter. So, your lordship, we have filed this appeal as because the railway was not being made party. So now if the respondent side, they have also agreed to the matter that it may be remanded back to the reference court for further fresh reference, your lordship. If your lordship may permit, it may be transferred to the. for
Yes, my
proper
lord, I
reference.
support that because it is, if the railway has not been made a party, so it will be, I am appearing for the state of Assam. So it would be fair, my lord, they should be heard because so much money is involved, public money is involved. 308 bighas of land, my lord, way back in 88, it was acquired. And it's still going on. So that would be fair, my lord, because it may be settled there also. The amount of land that was acquired was very high, 308 bighas.
Where is that judgment?
Here, I have the next. At page number 10 of the appeal, memo of appeal, your lordship.
Page number 10.
Yes, your lordship. Your lordship, two issues have been framed here. But nowhere it has been mentioned that the railway should be made party to it and but issue number 1 and 2 are regarding the value and as well as the next one is regarding the entitlement of the 30% additional compensation and 12% solatium and 9% interest. So these were the issues, those are framed, your lordship.
The land was acquired by
Land was acquired by the.
railway.
Yes, your lordship. Railway, NF Railway.
The government has acquired on
Yes,
the
on behalf of NF Railway.
NFL level.
Yes. Your lordship, we have specifically mentioned there in ground number 4 of our memo of appeal, your lordship, that for that the learned ad hoc additional district and session judge ought to have taken note of the fact that the learned collector determining the value of the land in question in conformity with the standard laid down in section 23 of the act. Though the learned collector scrupulously followed the parameters laid down by the section 23 of the act for the purpose of valuation of the land, but the learned ad hoc additional district and session judge ignored these very parameters while determining the quantum of award for land in question. So likewise, we have mentioned that the interest part is also that has been enhanced here. It is not liable because until and unless the railway is being heard in this particular matter. So the enhancement is also unable, railway cannot take the enhancement, your lordship. Or make the enhancement. So if they are freshly heard, your lordship, then they can take some decision, your lordship.
Third Miss M. Chatterjee, learned counsel for the appellant. And Mr. Bhattacharya, learned counsel for the
Respondent 6.
respondent number 6.
I'm appearing for person, private respondent.
For respondent 1 to 5.
No, there is a state of collector of Assam. Collector Kamrup Guwahati is performer respondent.
Yes, yes.
You are representing him.
I am appearing for a collector Kamrup, respondent.
Yes, he is performer respondent.
Yeah, my lord, they are doing everywhere, my lord. In every case, they're doing, my lord. In the airport authority cases also same thing.
Government advocate for the respondent number, performer respondent number 1, and Mr.
MJ Gogol.
Learned counsel for the respondent number 1 to 5. Any objection?
We have already filed our affidavit in opposition order. That may be remanded.
Remanded.
But the time frame may be fixed.
Yes, your lordship. The time frame may be.
It is submitted at the bar that while making reference to the court of learned ad hoc additional district and session judge Kamrup Guwahati, the collector Kamrup Guwahati had not arrived the NF Railway, the appellant hearing as a party, and the impugned judgment and award, judgment and order dated 28/11/2003 was passed without affording any opportunity of being heard to the present appellant. Though the landing question was acquired for the present appellant and the compensation amount was directed to be paid by the present appellant. And as such, the matter may be remanded to the learned court below with a direction to hear and dispose of the matter within a period of 3 months,
6 months.
6 months, within a period of 6 months. And having heard the submission of learned counsel for both the parties, I have carefully gone through the petition and the documents placed on record. Then I find substance in the submission. So advance at the bar. And taking note of all the facts and circumstances, and as agreed by learned advocates about the parties, the impugned judgment and order dated 28/11/2003 passed by the learned ad hoc additional district in session judge Kamrup Guwahati M in Miss Reference Case number 49 of 1999 and Miss Reference Case number 84 of 1994 stands set aside and quashed. The matter is remanded to the learned trial court. No, to the learned court below with a direction, no, with a request. No, with a direction to hear and dispose of the petition. No, dispose of the reference after affording an opportunity of being heard to the present appellant. And the dispose of the matter as early as practicable, preferably within a period of 6 months from the date of receipt of certified copy of this. Now, from the date of receipt of a copy of the order of this court. In terms of this LAA says disposal. Rescisal send down the record to the learned court below forthwith with a copy of this order. In terms of the miss case number 2401 of 2014 also is since closed.
So item 12,
Obliged judge.
item 12,
May I please, Your Lordship?
Yes,
This application is filed against the order of framing issue as regards res judicata and to hear that issue as a preliminary point to be not. Against that I am there. The impugned order is at page below 40. May I read below? Both sides are represented. By petition number so for learned counsel on behalf of the defendant has paid for filing of WO against petition number so which is sealed and allowed. Today is fixed for order on petition number so praying for hearing issue of law. A preliminary issue under order 14 rule 2 of CPC. Heard the parties on the last date fixed. I have bestowed my annexious consideration on the submission made by the learned counsel on behalf of the body parties. By petition number so the plaintiff states that the subject matter of the present suit was also subject matter of TS case number of the Honorable Court, which was filed by the present defendant against the predecessor of the plaintiff Dhanpal Gwala. That suit was decreed in favor of the present defendant and appeal was filed against it by Dhanpal Gwala, registered as TA case number so. The appeal was dismissing, affirming, and judgment passed by this court, and thereafter the said Dhanpal Gwala preferred second appeal before the Honorable Guwahati High Court. Filed RSA number so. The second appeal was dismissed by the Honorable High Court. Filed order dated so, affirming the judgment passed by this court. After that, the decree passed by this court was sought for execution by title suit number so during the pendency of the execution proceeding. The present plaintiffs filed a petition under section 47 of CPC registered as Miss J case number so, which was dismissed by the court. The defendant therefore prayed that under the facts and circumstances, the instant suit is barred by res judicata and therefore prays for taking it a preliminary issue and deciding the same. The plaintiff has filed written objection against the petition filed by the defendants. The plaintiff plead that the instant is not maintainable in law as well as facts. The same is liable to be dismissed and it has been filed at a belated stage. the plaintiff has denied the contention of the defendant that the subject matter of the present suit is the same as the as that of title suit number so and so. The plaintiff denies the rest of the averments made by the defendant. The plaintiff has stated that the present suit is not barred by principle of res judicata. Now, upon going through the CR as well as prayer of the defendant, it is seen that the defendant in their WS raised the issue of the suit being barred by principle of res judicata. The subject matter of the instant suit was also a subject matter in TS case number so and so. It is seen that the parties are also same in both the instant suit as well as TS number so and so. The judgment and decree passed by the TS case number so and so attained finality in the second appeal was also dismissed by this honorable court by judgment and order dated so and so. Order 14 rule 22 of CPC lays down that where the court is of opinion that the case or any part thereof may be disposed of on an issue of law, only it may try a issue first if relates to a bar of the suit created by any law for the time being in force. In the present suit, after going through the CR, it appears that the same might be hid by the provision of section 11. Therefore, in the light of the discussion made above, prayer of the defendant is allowed. The issue whether the suit is barred by principle of res judicata is to be decided as a preliminary issue. Petition number so and so is disposed of. Fixing so and for hearing on preliminary issue. Not only frame the issue, but also directed to hear that issue. Because res judicata. Res judicata is a mixed question of fact and law. It can be decided only when after taking evidence, after completion of full-fledged trial. But in this case, learned trial court at the initial stage decided to try.
No, the issue was raised before the trial court. The
Yes.
trial court has deemed it fit to decide it as preliminary issue.
Yes.
What wrong with the order?
Yes, my lord, but because for hearing of a preliminary issue, my lord, he is going to hear the preliminary issue at the initial, and that is barred, my lord. Under order 14, rule 22, that was barred. This honorable court in several cases says that piecemeal trial cannot be allowed, my lord. Because once he found that it is not, then again he will go to the main trial, that is not allowed. Secondly, this issue itself is not liable to be framed. Not liable to be framed because the earlier suit was of recovery of possession. They filed it for recovery of possession. Yes, that got attained finally. My suit is that the decree obtained by them is a fraudulent one, my lord. So subject matter is completely different, my lord. Cause of action is different, my lord.
Yes, Mr. Biswas.
There is no error committed by the learned court in framing the preliminary issue. So far as framing preliminary issue is concerned, after the amendment of the Order 14 Rule 2 in the 1976, a discretion has been given to the court either to frame or not to frame. Earlier, before the amendment, there was a mandate on the part of given to the court to decide the issues if it hit by any bar or if it is barred by any law, to decide it preliminary. But after the amendment, it has been given, the power has been given to the court either to decide or frame or not to decide or frame, because the judgment has to be given on all issues. So far as this present case is concerned, it is just a abuse of the process of court, because earlier the same suit was filed by us against the predecessor interest of the present plaintiffs. That suit was decreed in my favor. They filed an appeal dismissed. They came to this honorable court by a regular second appeal. The second appeal was dismissed. The issue was decided. Now here in the prayer is they are now seeking a declaration of right title interest of the present plaintiffs, who are the descendants of the earlier defendant against whom we filed a suit. The issue is settled that they do not have any right title interest over the plot of land. So their suit appeal was dismissed and regular second appeal was also dismissed. Here now the second prayer is a decree for setting aside the cancellation of the decree. The decree which has attained finality in this before this honorable court, now they are trying to challenge that decree, whether it can be permissible. And there is a judgment of 2022. If from a plain reading of the plain and the contents of the plain and the prayer, it can be ascertained that the contents and the prayer are similar to the earlier suit, then court can frame a preliminary issue. And regarding the piecemeal trial, if, my lord, the evidence is required, my lord, preliminary issues are those, my lord, where no evidence is required. Here, by going through the plain and the prayer of the earlier suit and the present suit, it can easily be ascertained that the subject matter of the suit is as same as the earlier suit. So there is no bar created by the act that the court cannot issue a preliminary issue. I will rely on the judgment of 2022. Paragraph 21 straight away, if I may take a lordship. Paragraph 21.
Yes.
The provisions of Order 14 Rule 2 are part of the procedural law, but the fact remains that such procedural law had been enacted to ensure expeditious disposal of the suit. And in the event of setting aside of finding on preliminary issue, the possibility of remand can be avoided, as was the language prior to the unamended Order 14 Rule 2. If the issue is a mixed issue of law and fact, or issue of law depends on the decision of fact, such issue cannot be tried as a preliminary issue. In other words, preliminary issues can be those where no evidence is required, and on the basis of reading of the plaint or the applicable law, if the jurisdiction of the court or the bar to the suit is made out, the court may decide such issue with the sole objective for the expeditious decision. Thus, if the court lacks jurisdiction or there is a statutory bar and such issue is required to be decided in the first instance, so that the process of civil court is not abused by the litigants who may approach the civil court to delay the proceeding on false pretext. And now, on the basis of this suit, now they are trying to stall the proceeding of execution of the decree that was obtained in the year 1999. And it is not the first case. There are 5 more cases they have filed before this honorable court. All these civil division petitions were dismissed. Sometimes they file section 47 petition. Sometimes they file order 21 or 97 petition. All those petitions came up before this honorable court by of a revision petition. All those petitions were dismissed. In some of the petitions, a cost was imposed, saying that these all are the abuse of the process of the court. Well, they are fighting for a suit land which doesn't belong to them. It has been settled by this honorable court. And so far as the framing preliminary issue is concerned, it is an interlocutory order. There is no bar created by the statute that the court cannot frame a preliminary issue. It is, of course, after the preliminary issue is decided, if it comes against them, then they have a remedy before the court. But unless and until a decision comes, merely because an order is passed in the interlocutory nature, whether it can be challenged by a revision petition, because there is no jurisdictional error, my lord, as my lord required under Article 227 of the Constitution of India.
Right, Your Lordship. Lordship,
And wait, the other judgment you have referred to is
I have referred to this only, and another is 2020, para 21. It says, for the purpose, the lordship has got. Paragraph 21.
yes.
For the purpose of disposal of the suit on the admitted facts, particularly when the suit can be disposed of on preliminary issues, no particular procedure was required to be followed by the High Court. In terms of Order 14 Rule 1 of the Code of Civil Procedure, a civil court can dispose of a suit on preliminary issues. It is neither in doubt nor in dispute that the issues of res judicata or constructive res judicata, as also the maintenance of the suit, can be adjudicated upon as preliminary issues. Such issues, in fact, when facts are admitted ordinarily, should be decided as preliminary issue. But there is no denial that the earlier suit filed by us doesn't contain the suit land, my lord. The suit land here in the earlier suit are same, and the parties are also same. Just because they are the descendants of the earlier defendant, they are now taking the chance to file a suit to challenge the decree that has attained finality before this honorable court. Whether it can be done, my lord. This is a shared abuse of process of law, my lord.
Yes, Mr. Saho.
Yes, my lord. The earlier suit was of, my lord, for recovery of possession. Now, this suit is for declaration that that decree was obtained by fraud. Kindly come to page 12, my lord. Kindly come to page 12. Page 8, that is the plain, my lord. 11 portions are at page 12. Paragraph 12, my lord. May I
Yes.
read? That Dhanpal Gwala, the predecessor interest of the plaintiff, was the co-owner and recorded partaker of the land left by the original owner, late Malo Gwala, as is legal heirs. But the defendant, by illegal means, by fabricating a false sale deed and basis of whom he has filed a suit for declaration of right, which was later on decreed by the learned trial court. The defendant had obtained the judgment and decree in TS case number on fabricated documents by misleading the honorable court. Now 13, that the defendant had instituted a suit upon a fabricated sale deed being number so and so, stated in paragraph 7 of the said suit. But evidence, the defendant exhibited a separate sale deed so and so, which was a fabricated document as per RTA given, reply given by the office of the sub-register so and so. Next 14, that the defendant obtained the decree of TS number so and so against plaintiff by playing fraud upon the honorable court on the basis of some false and fabricated documents. The said document was known to the plaintiff on so and so.
No,
when
Mr. Sahu.
my lord,
It second appeal preferred by you also dismissed by this court.
yes, my lord.
Then what
Now,
is
not
the
this
scope?
point. Fraudulent point is come later on, my lord. This course of action has arose later on. Earlier, only issue was decided whether he has right title interest or he is entitled to the recovery of possession or not. Later on, they have said that we have come to know that a decree was obtained by fraudulent manner. So this is a pure question of fact which requires evidence. A similar kind of case was decided by this honorable court. My lord, that 2009. In this case, my lord, earlier suit was for decree for recovery of possession. That was allowed. That was decreed, ex parte. Thereafter, the defendant side filed a suit for declaration that that decree was obtained by fraud. And this honorable court, my lord, what had observed, my lord. Kindly come to paragraph 11, my lord. Sorry. 2009. Oh, sorry, my lord. Paragraph 9, my lord. May I read, my lord? Paragraph 9.
Yes.
While admitting the appeal, the following substantial question of law was as framed. Whether separate suit for abiding ex parte decree on the ground of fraud is maintainable, because later suit was filed on the ground that the earlier decree was obtained by fraud. Now, paragraph 11, my lord. During the course of argument, Dr. Bhattacharya, learned counsel for the respondent, had pointedly questioned whether there is any absolute or specific bar for instituting a separate suit questioning the legality of a decree on the ground of fraud. Learned counsel fairly considered that there is no such specific bar insufficient. Now, my lord, paragraph 12, that law is, my lord, discussed. Now kindly come to paragraph 14, my lord. It is true that ordinary course the appellant ought to have approached the same court by filing an application under Order 13, Order 9, Rule 13, or he could have filed an appeal under Section 96 because that was decided ex parte. However, when an allegation of fraud was made by the plaintiff, the the courts below were expected to examine the allegation of fraud instead of dismissing the suit at its threshold on equitable grounds. Besides this, the impugned judgment suffers for material irregularity in as much as the allegation of fraud has been heard and decided as a preliminary issue, which in my opinion cannot be considered within the parameter of clause A and B of Rule 12.2 of Order 14 CPC, which relate to deciding a suit on preliminary issue. With a similar case, that in paragraph 3, that about the earlier suit, this was discussed, mentioned.
Okay, we'll see.
And thereafter, that 2006 to GLT. Paragraph 13. By Civil Procedural Code Amendment 1976, the earlier existing word shall was replaced by the word may in whether to frame a preliminary issue or not in the fact of circumstances of a particular case. There should not be any piecemeal trial in a single suit. This was my lord. There may not be any piecemeal trial in a single suit. Accordingly, when any evidence is required to be recorded or gone through in support or against such a prayer, in that event, the refusal of the learned trial court to frame such refusal issue cannot be said to be unjust, improper, or illegal. So. My lord, here evidence is required, my lord. When evidence is
Why?
because
In
that allegation made in paragraph, page 12, my lord. Of my
no.
plaint.
In your case,
Yes,
by reading the plaints of both the petitions,
yes,
both the plaints, reading the pair portion of the both the plaints,
my lord.
it can be ascertained why evidence is required.
My lord, kindly prayer at page 13, prayer 2. Prayer 2, my lord. Prayer 2. A decree for setting aside cancellation of decree dated so and so passed in TS case number so and so by this honorable court as nullity, as the same was obtained by playing court. That was there, my lord. Again, a decree that impugned decree passed against the plaintiff, so is not binding upon the plaintiff. Plaintiff, as the same was obtained by fraud. So, my lord, this cannot be, my lord, same. And similar issues was decided by this honorable court, my lord. I have already referred to that, my lord. And the 2006, my lord, that judgment says that where evidence is required, no piecemeal trial is allowed, my lord. Now here, by framing that issue and going to decide that issue as a preliminary point, the learned trial court has intended that he is going to make a piecemeal trial.
No, here recording of evidence is not required
My lord,
to decide the preliminary issue. Recording of
course, my
evidence
lord,
is
but
not required.
whatever is on the record that says that evidence is required, because I have already I've already, my lord, said that paragraph 12, 13, 14, allegation of fraud was there. I must have get an opportunity to prove that those allegations by adducing my evidence, my lord.
Okay. Heard Mr. Sahu, learned
But I
counsel
will
for the.
take your lordship 5 minutes, and your lordship perhaps will rise. This judgment relied on by my landlord friend is in the same proceeding. There was an ex parte order.
Mm,
So in the regular second appeal, a substantial question of law was framed.
mm,
Here the case is totally different. Here the allegation of fraud they are raising for the first time, not in the first appeal, not in the second appeal.
mm,
It is a by of a separate proceeding just to halt the proceeding of the execution of decree obtained in 1999. Instead of my lord challenging the regular second appeal before the higher forum, now by of the civil division petition, now by of a separate suit, they are challenging whether it can be done. And from a plain reading of the plain and the prayer, it can be inferred that the contents and the subject matter of the suit and the parties are same.
mm.
Whether it will be a going concern that every time a decree is passed, they will come up with fraud, allegation of fraud. Allegation of fraud is not the subject matter. Subject matter is whether the suit is filed on the same for the same suit length between the same parties, whether it is barred by the principal or
judicata.
adjudicata. And law is very settled where no evidence is required, my lord, it can be framed. Otherwise, it will be abuse of the process of court.
Because the 2009, that is squarely covers. because there-
2009 also, my lord.
Wait, two suits are there, my lord. In that case also, two suits were there.
Okay, we'll see.
My lord,
And also heard Mr. Visas, learned counsel for the respondent, argument concluded, order is set. Thank
What
you.
of it?
The lordship permission to examine the file, my lord. I would like to examine the file once again.
Yes, Oh.
And that I wanted to withdraw the petition may be kept in abeyance. Because I have noticed what is the problem.
okay. Verma, learned counsel for the petitioner, and Mr. Gupta, learned CGC for the respondent number 1, 2, and 3. None appears for the respondent number 4 and 5. Mr. Sharma, learned counsel for the petitioner, submits that pursuant to the order of this court dated 21/10/2024, the petitioner was admitted and the grievance sought to be addressed in this petition has already been addressed by the respondent number 1, 2, and 3. And as such, the matter become infractious and the same may be closed. Accordingly, this WPC is closed.
Number 13.
In this case, my lord, your lordship last occasion directed me to file affidavit as a last chance, my lord. Today, my lord, my humble prayer, let the matter come on Wednesday, my lord. The instruction received by me, that is not sufficient, my lord. So I pray a little bit accommodation, my lord. If your lordship, our lordship may.
Okay, on
Lordship.
Tuesday then, or
Yes,
Wednesday.
Wednesday, my lord.
Wednesday.
That was the last time, Lordship. There's 2 times the Lordship.
I know, my lord, the last.
If we file a
Maybe
Wednesday, then I have to file reply prior to date, Lordship, on fixed date. Before
Or
Wednesday,
Lordship
so
may-
that I can reply to that, Lordship. I'm not getting salary from March 2015, in the minute I have retired, Lordship. Even the
is
pensionary benefit. I
Admitted
get
fact,
back,
my lord, admitted by the department, my lord, that he is not getting the
This case
salary.
is covered by the judgment of the Supreme Court as well as High Court, Lordship.
My lord.
And since my service has been utilized, I'm entitled to get a salary as well as pension also.
Only in.
Heard Mr. S.U. Ahmed, learned counsel for the petitioner, and Mr. Talukdar,
Without the, my lord.
learned standing counsel for the
Elementary
respondent
education.
for 1, 2, and 3. And
He does appearing on behalf of B. Sharma, standing counsel AG.
he does learned counsel appearing on behalf of Mr. B. Sharma,
Standing counsel.
learned standing counsel for the respondent number 5, and Mr. Bhattacharya
Pension department.
for respondent number
6.
Respondent number 6. Mr. Talukdar, learned counsel for the respondent number 1, 2, and 3, submits that he has received instruction, but the same are not sufficient. And as such, he may be granted some more time to file his affidavit in opposition. There is accordingly allowed. List the matter on Wednesday,
6th.
6. It is provided that no further sums will be given to Mr. Talukdar
My
to
lord.
file his affidavit in opposition.
Item
Yes, my lord.
14.
May please your lordship, this is a cover matter, lordship. On our last three occasions also it was listed, lordship.
Lordship, here I will have the instruction, Lordship, I will file affidavit. And moreover, Lordship, here I am appearing for the education department and finance is also necessary party. Finance has not been made as a necessary party, here, Lordship. Finance has not yet, in fact, been made a party. So finance is the necessary party here. And for the department, education department, I will file affidavit, Lordship, fix after 3 weeks, Lordship.
Is it necessary to implement the
Not-
finance
not-
department?
The prayer of the petitioner is asking for the pension in terms of the old pension rule also. So therefore, the finance is the party, necessary party.
Heard Mr. P. Bordoloy, learned counsel for the petitioner, and Mr. Sharma, learned counsel for the respondent.
May I submit one thing?
1, 2, 3, and 4 also.
1, 2, and 3.
One of the petitioner is going to retire next year, lordship, March.
Next year, also, you have time. I will file the affidavit in 3 weeks also.
Within 3 days.
3 weeks.
No, short date.
2 weeks.
On the last three occasions, they took time, lordship. Now they are.
1 week, 1 week.
Even the affidavit from the finance is also required, no issue.
Okay, we'll direct to implement the finance department. You
Lordship,
call
lordship.
service of notice today itself, if possible.
Lordship.
Mr. Sharma, learned counsel for the respondent number 1, 2, and 3.
1, 2, 3, and 4.
1, 2, and 4
1, 2, 3, all the responses as of now.
for all the respondents. Mr. Sharma submits that he may be granted 3 weeks' time to file affidavit in opposition. However, Mr. Sharma is granted 2 weeks' time to file his affidavit in opposition. Mr. Sharma further submits that in view of the grievance sought to be addressed in this petition, the finance department has to be implemented as respondent in this petition. In view of the submission of Mr. Sharma and in view of the facts and circumstances on the record, this court is inclined to implement the finance department as respondent number 5. Let notice be issued to the newly implemented respondent by registered post with AD and also by usual process within a week from today.
Lordship, their standing counsel is there,
Uh,
therefore, registered post. it
Not
is
necessary.
required, lordship.
Okay,
Normal steps will do, lordship.
step be taken only.
Lordship.
List the matter after 2 weeks. We will fix it at then.
Lordship.
Lordship, you have entered appeal.
Mr. Borthakur, you are for finance department. Okay. Later on, Mr. Borthakur, learned standing counsel for the finance department, entered appearance and received notice. So no formal notice is required to be issued. However, extra requisite copy of the petition may furnished to Mr. Borthakur during the course of the day. List the matter on
18th.
18th.
Of November, my dear.
18th of November.
Oblige.
May kindly record my name is R. Borpuzari.
R. Borpuzari.
Item 16.
Oblige. Lordship.
My lord, this civil revision is directed against an order passed by the civil judge Kibo Hagar.
Hmm.
So, my lord, we as plaintiffs had instituted a suit for partition. My lord. We have 5 sisters, my lord. And in that partition suit, we had obtained an order of injunction.
Hmm.
That order of injunction, your lordship finds at page 39, and the operative portion is at page 46. my lord.
Hmm.
The last paragraph, also why with the order dated 5/4/21, this court had already granted an interim injunction restraining the OPs from transferring and or alienating the properties described in Schedule B5 to the plaintiff till disposal of the injunction application. Therefore, until the issue of partition is decided in Title Suit 10 of 21, this court is of the considered opinion that for the ends of justice, both sides who are close relatives, order of ad interim temporary injunction until disposal of the suit is passed, restraining the opposite parties from transferring, alienating, encumbering, changing the nature and character, as well as creating third-party rights to the properties described in Schedule B to the instant application, as well as restraining the opposite party from changing, altering the shareholding of Bonomali Tea Estate in any manner whatsoever till disposal of the suit. So, my lord, among B5, the Schedule B, there are several properties. One property was situated at Shillong, my lord. Now, later on, we filed an application under Rule 2A alleging violation of this particular order, which your lordship finds at page 48. Now, the moot allegation of violation was that despite the order of injunction, they have inducted new tenants in that house in Shillong. Now, page 50, your lordship finds the relevant allegations. Paragraph 5. Page 50, paragraph 5. That after institution of the instant suit and granting of injunction order dated so and so by this court, the opposite parties and their agents had started to prevent the petitioner from accessing the Schedule B5 premises. That recently in the month of March 23, the petitioner came to know that few persons have been illegally inducted in the said premises. It has been learned from reliable sources that a fresh lease has been created in respect of a portion of house situated over the property. It is pertinent to mention herein that earlier one Samrat Deka was leased out a portion of the said house. The said lease is learned to have expired in the month of February 2023. It has further been learned that the said lease with Samrat Deka has been renewed, notwithstanding the order dated 5/4/21. Further, the portion of house which was lying vacant as on the day of passing of the order dated so and so has been leased out to a new lessee in violation of the ad interim order. Therefore, the defendants opposite parties may be directed to produce all records pertaining to such transfer. So we said that they have been creating third-party rights in respect of the house. Now, they filed the objection at page 58, my lord. And para 6 is their response to this allegation about leasing out the premises in violation of the injunction order. At page 16. That it is denied that recently in the month of March 23, a few persons were illegally inducted in the premises of Schedule B5 property, and that a fresh lease had been created in respect of a portion of the house situated over the said property. Sri Samrat Deka has been occupying a portion of the house of Schedule B5 of the plain as licensee under license granted by late Ojit Choliha, the predecessor in interest of the opposite party, since 1/11/2017. After the death of Choliha, the said Samrat Deka continued as a licensee, and in 1/5/2019, the since Samrat Deka took the remaining portion of the house as licensee under the answering opposite party. So they basically took a defense that this lessee has been there for before, and he was inducted by our predecessor, and these leases have come prior. These are licenses which were done earlier in point of time. Now, in support of their contention, my lord, this is where the problem arises. They rely on a few leave and license agreements to say that these agreements were prior to the injunction order. Now, page 89, if your lordship may kindly take up. So they annex a series of leave and license agreements to depict that all of this was done prior to the injunction order. Now, first is page 89. This is the agreement of lease dated first day of September 2019. For a moment, your lordship will kindly mark with the serial number in that stamp paper. It's 192775. Has your lordship seen it? Now, next agreement is at page 96. This is 1st of August 2020. This is for the following year. Now, if you
when the injunction order was passed?
Injunction order was initially passed in 21, and then ad interim order, and then it was affirmed in 23. So now they're showing previous leave and license agreement. Now, your lordship, at page 96, your lordship will again mark the serial number of that stamp paper 2774. The earlier was 2775. Now, page 103, again, if your lordship takes up. This is shown to be a leave and license of July 2021, strangely, this also has a running serial number 12772. Now, again at 110, there's a fresh, again, another lease is shown of 2022. And again, the serial number is a running serial number. Now, this naturally raises a doubt. And we reckon that all of this was done on one single day by buying stamp papers in bulk, so as to negate my plea that the injunction was violated. Now, to gather clarity on this, at page 117, we file an application that you produce originals of all the leave and license agreements, because on the flip side of the stamp paper, the date of issuance will be there. So we filed this application at page 117. We, at paragraph 5 at page 118, we make that allegation that perhaps all of this is backdated. So therefore, let them produce the origin. That a perusal of the non-judicial stamp papers upon which the agreements of leave and license dated so-and-so, so-and-so, and so-and-so were carried out could be seen that they bear a continuous serial number of the same series and were purchased in the same year. However, the agreements were executed in different years for licensing / leasing out the Schedule B5 property. It is relevant to mention herein that all agreements prior to the agreement dated 1919 were notarized before the notary public. However, the aforesaid agreements dated 1919, 1820, 1721, and 1622 were neither notarized by the opposite parties nor the signatures of the opposite party tally with the signatures in the agreement signed prior to 1919. Under such circumstances, petitioner raises doubt about the authenticity of the aforementioned agreements for leave and license, and it is presumed that they are executed subsequent to the passing of the interim order dated 5/4/21 and filing of the miscase number so-and-so to mislead the Honorable Court. So we say you produce the original, then we'll know the date of issuance of the stamp paper. Now they file a written objection at page 123. Now they are shying away from producing the originals. And paragraph 5, if your lordship sees at page 125, their explanation as to why there is a continuous serial number, that in paragraph 5 of the petition, the petitioners have referred to the running serial number of non-judicial stamp papers, and that the agreements are not notarized, and alleged that the agreements were executed subsequent to the passing of the injunction order. Now, my lord, the explanation. It is submitted that in the year 2019, the COVID pandemic started, which continued for succeeding years. As OP defendant number 1 is of advanced age and is a cancer survivor, it was not possible to execute fresh grant of license to the licensee during the pendency of pandemic. Therefore, the existing licensee Samrat Deka was granted verbal permission to continue as the licensee, and it was agreed that for record keeping purposes, the license agreements would be executed once the pandemic was over. Thereafter, in the year 2022, the opposite party secured the non-judicial stamp papers and executed the agreement. As time had already passed, the agreements could not be notarized. So the cat was out of the bag, and they virtually admitted that because of pandemic, we could not do it. Therefore, we purchased it on bulk, and we have done it backdated. Not in so many words, but it is understood that that was what their defense was. Now, with this, in fact, the violation already stood proof, but nevertheless, this application for production of the originals were taken up for consideration, and the impugned order, your lordship finds at page 172, 28/3/2024. Now, turning to page 175, my lord, we'll find the reasonings.
Hmm.
175, my lord, the third paragraph, all the documents. Has your lordship seen it? All the documents in the list of the OPs are documents of leave and license agreement of different dates ensued since 2017 prior to institution of the suit and continuation thereof till 1/6/2022. In his argument, Mr. So-and-so for the OPs has rightly pointed out that the petitioner has incorrectly referred to license agreements as lease agreements. Perusal of the document makes it clear that neither of the documents listed by the OP refer to granting of lease of any property. The operative part of the order dated so and so that the petitioners prayed for ad interim injunction restraining the so and so from transferring and or alienating the properties described in Schedule B5 to the application till disposal of the injunction application was allowed. Also explicitly speak that the petitioners did not have prayer for restraining the OPs from granting license. The entire discussion makes out the aforesaid documents irrelevant for disposal of issue of violation order dated 5/4/20 or petition plea in para 3 of the incident application found irrelevant, inconsistent, and vexatious, and it was dismissed. Now, two things, my lord. First of all, the learned trial court was not even taking up the application for violation. The occasion was only to decide whether these documents are required to be called for in original. My lord, here the learned trial court virtually enters into the merit of the violation application and says that these are license agreements and not lease agreements. So this is not violation. So it had prejudged the issue of violation. That's number one, my lord. And secondly, my lord, it failed to consider one cardinal rule that nomenclature of the document will not determine what it is. It could be termed as a license, it could be termed as a tenancy or whatever, but the court has to gather the real purport of the document from a reading of the clauses. The heading is not sufficient. Because the moment it's a license, it comes under Easement Act. If it's a tenancy, it will come under the State Rent Act. And this is something which has been dealt with by the courts on numerous occasions, that the distinction between a license and a lease has to be gathered from the true nature of the document, the circumstances that are. This is the case of associated hotels, para 28. So first of all, this distinction ought not to have been gone into, my lord, first of all. That is something which the trial court could have left to be decided at the time of deciding the violation application. But it prejudged the issue, therefore, I'm placing the law, my lord. Okay. Now, para 28, my lord. There is a marked distinction between a lease and a license. Section 105 of the Transfer of Property Act defines a lease of immovable property as a transfer of a right to enjoy such property made for a certain time in consideration for a price paid or promised. Under Section 108 of the said Act, the lessee is entitled to be put in possession of the property. A lease is therefore transfer of an interest. The interest transferred is called the leasehold interest. The lessor parts with his right to enjoy the property during the term of the lease, and it follows from it that the lessee gets the right to the exclusion of the lessor. Whereas Section 52 of the Indian Easements Act define license does. When one person grants to another or to a definite number of other persons a right to do or continue to do in or upon the immovable property of the grantor something which would, in the absence of such right, be unlawful, and such right does not amount to an easement or an interest in the property, the right is called a license. Under the aforesaid document, if a document gives only right to use the property in a particular way or under certain terms, while it remains in possession and control of the owner, it will be a license. The legal possession thereof continues to be with the owner of the property, but the licensee is permitted to make use of the premises for a particular purpose. But for the permission, his occupation would be unlawful. It does not create in his favor any estate or interest in the property. There is therefore clear distinction between the two concepts. The dividing line is clear, though sometimes it becomes very thin and even blurred. At one time, it was thought that the test of exclusive possession was infallible, and if a person was given exclusive possession of a premises, it would conclusively establish that he was a lessee. But there was a change, and the recent trend of judicial opinion is reflected in Errington versus Errington, where Lord Denning, reviewing the case law on the subject, summarizes the result of his discussion thus. The result of all these cases that although a person who is let into exclusive possession is prima facie to be considered to be a tenant, nevertheless, he'll not be able to he'll not be held to be so if the circumstances negative any intention to create a tenancy. The Court of Appeal in Cobb versus Lane considered the legal position and laid down that the intention of the parties was the real test
to ascertain the character of a document. At so-and-so, Somerville LJ stated the solution would seem to have been found is as one would expect that it must depend on the intention of the parties. Denning said much to the same effect. The question in all these cases is one of intention. Did the circumstances and the conduct of the party show all that was intended was that the occupier should have a personal privilege with no interest in the land? The following propositions may therefore be taken as well as established. To ascertain whether a document creates a lease or a license, the substance of the document must be preferred to the form. The real test is the intention of the parties, whether they intended to create a lease or a license. If the document creates an interest in property, it is lease, but if it only permits another to make use of the property of which the legal possession continues with the owner, it is a license. And 4, if under the document a party gets exclusive possession of the property, prima facie he is considered to be a tenant. But circumstances may establish which negative the intention to create a lease. Judged by these tests, it is not possible to hold the document as one of license. Now there are other judgments, my lord, which have again said that form is not material. Now the trial court has very readily inferred that, oh no, this is a license, so the question of violation doesn't arise, and I need not even call for these documents. But it did not really apply its mind what was the intention of the parties, whether there was transfer of possession, whether it truly was a license or a lease. Because another aspect is these are in Shillong, so perhaps registering a lease would be difficult. So they style it as a license. But at the end of the day, if the substance is looked into, it may transpire to be a lease. Now, all of this could have been dealt with by the trial court at the time of violation. At this particular juncture, we were only there to seek production of the document so as to see this, so as to allay this confusion as to why are they running serial numbers for each year. And from the written objection, it more or less transpired that they had admitted that they had resorted to backdating of the documents so as to escape from the allegation of violation. So, my lord, given this, and in fact, if your lordship sees, the signatures are also different. So that gives, even to the naked eye, will seem a little different. So given all of this, we wanted the originals, and the flip side of the stamp paper would have reflected on which date it was issued, whether it was prior to injunction or after the injunction. So to ascertain whether there has actually been a violation, these documents were essential, number one. Secondly, my lord, the impugned order has gone beyond deciding what was there in the application and has gone on to decide the merits of the violation application itself.
Yes, Mr. Bartozari, you are there.
Yes, Malak, I am representing all the respondents, 3 respondents.
Hmm.
We can resume at 2, my lord.
Okay, another 10 minutes we can continue.
I will take some little time, my lord.
All right.
My lord.
You start it.
Yes, yes. My lord will kindly see their application for violation of the injunction order. That lordship will find at page 48.
Yes.
Now, page 48 is the, my lord, genesis of the violation, my lord, part. And what is there, my lord? Kindly see in the cause title, an application filed on behalf of the petitioner under Order 39 Rule 2 and 7, read with Section 159 of the Code of Civil Procedure against the opposite parties for disobedience and breach of order dated 5/4/2021. Lordship may kindly mark this. Breach, disobedience and breach of order dated 5/4/2021. Now let us see what is order dated 5/4/2021, because they are alleging violation of that order. 5/4/2021 order, lordship will find at page 37. Page 37.
Yes.
Now, the suit has been, my lord, filed by the petitioners as plaintiffs before the learned trial court below at Sibsagar, my lord, claiming partition of certain part and parcels of properties. And till now, no preliminary decree as such has been passed in that, my lord, suit. So therefore, the parties to the suit are still in occupation of, my lord, the indivisible parts of the property. They are still in occupation. Now, 5/4/2021 order, lordship will find the operative portion at page 38. I will go by the admitted position in the record since I am not filing any affidavit. I will try to convince my lord by diagnosing the record itself to show that there is no violation. Page 38 down below, lordship will kindly see, my lord. I am reading it, my lord, the last paragraph. Given the present circumstances of the case, lordship got it, my lord. Given the present circumstances of the case and prima facie whatever facts have come to light, I find merit in the argument of the learned counsel for the petitioners, and therefore the petitioners' prayer for ad interim temporary injunction restraining the opposite parties from transferring and or alienating the properties described in Schedule B5 to the plain till disposal of the injunction application, that is Ms. case number 9 of 2021 is allowed, and the opposite side is asked to give reply as to why the same should not be made absolute. Issue notice to the opposite parties, petitioners to creditors. Now, this order is an ex parte ad interim injunction order. Their lordship, at this paragraph, lordship may kindly take note of my lord, these words, restraining the opposite parties from transferring and alienating. The words used by the trial court is transferring and alienating. Lordship may kindly mark this because they are alleging violation of this order, 5/4/2021. And what is the direction of the learned trial court? The learned trial court directs the opposite parties, that is the respondents out here, my lord, whom I am representing, that they are restrained from transferring and or alienating the properties. They are restrained from transferring or alienating the properties. Now, lordship is aware, my lord. Transfer can only happen, transfer or alienation can only happen, my lord, under the provisions of the Transfer of Property Act. Now, Transfer of Property Act, my lord, envisages, my lord, certain situations which can be termed as transfer. Number one will be, my lord, sale. Then second will be gift. Third is, my lord, lease. And the fourth is exchange. Now, save and accept these four modes of transfer. If any other mode is, my lord, acted upon, whereby the property is, my lord, given to use by a person to another person, it will have a different meaning. And in the present case, my lord, it is done by way of issuance of license. There being a leave and license agreement. Now, after filing of this application, which lordship has seen at page 48, because the application has come from the petitioners, that there is a violation of this direction, ad interim injunction direction, which lordship has just now seen at page 38, whereby the learned trial court below restrain the opposite parties from transferring and alienating the properties. And in that violation application, lordship will kindly see at paragraph 5, page 50. What is the allegation? What is the allegation of the petitioner's plaintiff? Paragraph 5, page 50. If I may read it, my lord. And so obliged, my lord. Paragraph 5. That after the institution of the instant suit and granting of injunction order dated 5/4/2021 by this honorable court, the opposite parties and their agents had started to prevent the petitioners from accessing the Schedule B5 premises. That recently in the month of March 2023, the petitioner came to know that few persons have been illegally inducted into the state premises. It has been learned from reliable resources that fresh lease has been created in respect of a portion of the house situated over the said property. It is pertinent to mention herein that earlier when Samrat Deka was leased out a portion of the said house, the said lease is learned to have been expired in the month of February 2023. It has been further learned that the said lease with Samrat Data has been renewed, notwithstanding the order dated so and so. Further, the portion of the house which was lying vacant on the date of passing of the order dated so and so has been leased out to a new leasee in violation of the ad interim order. Therefore, the defendant's opposite parties may be directed to produce all records pertaining to such transfer. And upon receipt of notice, my lord, in this violation proceedings, my lord, the opposite parties, they have, my lord, filed their written objection. And along with the written objection, they have, my lord, because lordship will kindly see the tenor of the language, my lord, and the pleadings that has come up, that has been filed, my lord, by the petitioners alleging violation. The prayer, my lord, in the violation application, lordship will find at page 52. I am troubling my lord with all these pages because I will have to, my lord, satisfy this honorable court.
Okay, no problem.
My lord, my lord, page 52. Kindly see the prayer in the violation application. In the premises aforesaid, it is respectfully prayed that this honorable court may be pleased to allow this application and be pleased to grant. Number A, appoint a commission to determine the status of property, which, my lord, is not the subject matter before this honorable court right now. Then B, call upon the opposite parties and direct them to produce the deed of conveyance. Kindly mark, my lord, this word, deed of conveyance. They themselves are unsure what is happening. Because if I allege, because violation has penal consequences. A proceeding under order 39 rule 2A is, my lord, in a nature of quasi-criminal proceedings. Because, my lord, there are penal consequences. If the violation is established, if the violation is proved, then, my lord, the person who commits violation of the injunction order is, my lord, may be penalized, my lord, to for imprisonment, my lord, in civil imprisonment. So there are penal consequences. And what they are seeking, my lord, they say, my lord, to direct the opposite parties to produce the deed of conveyance entered into. So what violation is exactly done by the opposite parties, the petitioners have not categorically spelled out. It is only spelled out, my lord, at paragraph 5, which the lordship has seen from their application, my lord, that they came to know, but they are not sure what they came to know. Now, upon receipt of notice in this violation case, my lord, the opposite parties, they, my lord, filed a written objection. And in the written objection, my lord, they have bona fidely placed all the records. It is not that, my lord, we could have said, my lord, that nothing is done. We could have simply said, no, whatever you have said are not correct. There is no lease, nothing. So there is no violation. Then the burden would have shifted to them. Only because of the fact that we have acted bona fidely and we have brought to the notice of the court that what is the true and correct picture of the state of affairs, my lord, in that property. So because, my lord, since we have brought on record this lease and license agreement, now, my lord, having found this lease and license agreement, they have now filed another application in that violation proceedings. Now they are seeking a direction from the court to produce the original ones. Earlier, they didn't have any knowledge. They had made only, my lord, vague allegations of violation, saying that the opposite parties, that is the defendants, my lord, they have entered into lease with some other parties. Now, since we have produced the documents, they came to know about the document. Now they have filed one subsequent application whereby they sought direction from the learned trial court below to direct the defendants, the opposite parties, to produce the originals. And whether that subsequent application is, my lord, relevant or required for adjudication of the violation proceedings. That is the precise issue here. I will satisfy, my lord.
Why don't I produce the original one?
No, it is not required itself because that is not relevant to the issue. That I will satisfy, my lord. It is not relevant because we have, even if we produce the original, that is also not going to serve any purpose because of the fact that we have to stick to the direction of, my lord, that interim direction. The direction was for not to transfer and alienate. Now, since it is available on record that leave-and license agreements are there, whether leave-and license agreement that are placed on record, which are also made a part of the civil division application, whether these amount to lease or not, that I will satisfy. Since that argument has been raised from that side, I will have to reply.
Okay, we will hear you
Yes, yes.
at 2 p.m.
Yes.
Yes. Yes.
As I was drawing my lord's attention to the order dated 5/4/2021, which was, my lord, the initial ad interim injunction order. Now that order was subsequently made absolute. In fact, that case, injunction case has been disposed of. Lordship may kindly see the subsequent order that Lordship will find at page 46. Page 46, I am reading the last paragraph, my lord. Also, while order dated 5/4/2021, this court had already granted an interim temporary injunction restraining the opposite parties from transferring and or alienating the properties described in Schedule B5 to the plain till disposal of the injunction application, that is Nizze case number 9 of 2021. Therefore, until this issue of partition is decided in Title 10 of 2021, this court is of the considered opinion that for the ends of justice to both sides who are close relatives, order of ad interim temporary injunction until disposal of the suit is passed, restraining the opposite parties from transferring, alienating, encumbering, changing the nature and character, as well as creating third-party rights to the properties described in Schedule B to the instant application, as well as restraining the opposite parties from changing and altering the shareholding of Bonamali Tea Estate Private Limited in any manner whatsoever till the disposal of the instant suit. Here, the tenor of the order, the initial order, and the tenor of the absolute order, subsequent order, is almost identical, to the extent that the opposite parties have been restrained from transferring, alienating.
That has to be.
Yes, no, because why I am making these submissions, because I am trying to, I will be making an attempt to make a distinction on the materials available on record, that these agreements are in fact leave-and license agreement. By these leave-and license agreements, my lord, the property has not been transferred or alienated. So therefore, now lordship may kindly come to the written objection filed by the opposite parties, my lord, in their application, whereby they have called for the original records. To that extent, lordship may kindly see. Lordship may kindly come to page 65.
Yes.
This is a part of the written objection filed by the opposite parties, my lord, against the violation application. And in the written objection, these documents have been, my lord, enclosed. In fact, these documents are copies of this leave-and license agreement are filed before the Honorable Trial Court. There are altogether, my lord, 7 documents. At page 65, lordship will kindly see. The first document is a copy of the leave-and license agreement entered into between late Ojit Sali and Sarmadika, that is dated 26/10/2017, much prior to the passing of that, my lord, an interim injunction order. And there are subsequent documents which are in continuation, my lord, of the RDI agreements. And this violation application tend to be filed, my lord, on March 2022. After almost about 1 year. The initial injunction order was passed, my lord, on 5/4/2021. Violation petition has been filed after 1 year in the month of March 2022, almost 1 year. So within 1 year, the petitioners did not make any sincere attempt to find out whether the property in question, my lord, situated in Shillong, Meghalaya, has been transferred or alienated. after almost about 1 year, my lord, they filed this violation application. Now let us see, my lord, the agreement for leave and license. Lordship may kindly see, my lord, page 67. This is the first of those leave and license agreements which have been enclosed, my lord, and produced copies, of course, my lord, have been produced before the trial court. Page 67, Lordship may kindly see, my lord, the second paragraph. Mr. Ajit Soliha, aged 50 years so and so, called and referred to as the licensor, which expression shall, Lordship may kindly mark this. Referred hereinafter called and referred to as the licensor, thereafter, which expression shall also include his legal heirs and representatives. In the third paragraph, Lordship may kindly see, and Mr. Samrat Deka, son of so and so, nationality in India, nationality Indian, resident of so and so, called hereinafter called and referred to as the licensee. Now the subsequent words are important. Which expression shall mean and include only the licensee is as named above. Lordship will kindly mark this, because lease is always heritable. If I effect a transfer under any of the modes, and he says under the Transfer of Property Act, that is by way of sale, by gift, or by lease, or by exchange. If any agreement to that effect is executed between two persons or two entities, then though the rights flowing from that agreement is always heritable. It is always heritable. I could have I could have perceived the situation if here at the third paragraph it is written that licensee, which expression shall also include his legal heir and representatives, but it is only limited to him. It is only limited to Samrat Deka. If Samrat Deka expires, this agreement also comes to an end. His legal heirs or his successors in interest, or my lord, his assigns agents will not have any say on this license. So therefore, the Honorable Supreme Court has said time and again, R.N. Kapoor has been relied upon by them. I will also be relying on one Supreme Court decision where the Supreme Court has laid down the principle that in order to find out whether an agreement is actually a lease agreement or it is a leave and license agreement, the intent of that agreement and the subject matter laid out in that agreement has to be read. Now, from paragraph 3, Lordship has seen that the right of occupation is not made heritable. It is limited. It is limited only to him. Why that expression is not here, my lord? Because it is only for a limited use. If it has been a lease, then it would have been written in a form that leasee, which expression shall include his legal heirs and representatives. But this is not the language. The language is licensee. Within bracket it is written, which expression shall mean and include only the licensee as named above. So therefore, my respectful submission is that this is not a lease agreement. And by this agreement, the property in question, which is the subject matter of the suit down below before the trial court, has not been transferred or alienated. If it is proved, prima facie proved on record before a court that this is a lease agreement, and by this lease agreement, this property, the property included in this agreement has been transferred or alienated, then I cannot escape. I am, my lord, in. But if I can show that this agreement is not, in fact, it is not a lease agreement, but it is a legal license agreement, then I am, my lord, protected. Then Lordship may kindly turn to the next page, page 68.
Yes.
Page 68. My lord, I am reading from the first paragraph, my lord. And whereas the licensor is desirous of giving one portion of the aforesaid building standing there on the said land and building on a leave and license basis. On a leave and license basis, Lordship may kindly mark this, on a leave and license basis. And on this one portion of the said land and premises is more particularly described in Schedule 1B attached hereto and hereinafter referred to as the Western Block. And whereas the licensor being approached by the licensee has made it well and sufficiently clear to the licensee the true nature of license and the license, then the licensor is desirous of granting to the licensee. So the parties to this agreement, leave and license agreement, has made it absolutely clear that this will not be a lease agreement, but this will be a leave and license agreement with a limited use. Then the next paragraph. That the said license is a license as defined under section 52 of the Indian Easements Act 1882 and is a personal lessor. Proxy may kindly mark this also. Because these my lord recitals in the my lord leave and license agreement are very much vital in order to determine whether this is actually a lease agreement or this is a leave and license agreement. According to the petitioners, this is a lease agreement. We say that this is a leave and license agreement. From the language, we have to find it out. Then it is said, my lord, that the said license is the license defined under section 52 of the Indian Easements Act 1882. Very specifically, it has been, the intention between the parties is loud and clear that this is not a lease agreement. It is a leave and license agreement. Then the subsequent paragraph, Lordship kindly see, that the said license is a bare, revocable, non-exclusive and restricted license. Lordship may kindly mark this also. That the said license is a bare, revocable, non-exclusive and restricted license to use the said Western Block for temporary residential purposes only. Restricted. Only for occupying that, my lord, part and parcel of that property. Subsequent thereto, Lordship will kindly see that the said license does not create transferable, assignable or heritable rights. What more is required? The parties themselves has come to a definite, my lord, intention. So therefore, there is consensus ad idem between the parties to the extent that this agreement is not a lease agreement. Rather, this agreement is a leave and license agreement. Then thereafter, further, my lord. And whereas, Lordship kindly see, my lord, and whereas the licensor has made it well and sufficiently clear to the licensee the provisions of the Meghalaya Transfer of Land Regulation Act 1971, more particularly section 3(1) of the said act, and the licensor hereby states and declares that the true nature of the license and the licensor is desirous of granting the license in compliance with section 3(1) of the act. Even, my lord, the statutory requirement has also been spelled out, my lord, in this agreement. In fact, my lord, in Meghalaya, there cannot be a, my lord, lease transfer of property, whether by lease, sale or otherwise, my lord, between my lord, domiciles of Meghalaya or non-domiciles. This is the law. Then, my lord, Lordship will kindly come down below, and I am reading, my lord, clause 1, nature of license. Lordship has seen it, my lord, at page 68, down below. Lordship may kindly mark this.
Yes,
also.
got it.
Yes. May I read it, my lord? Nature of license. Based on the declarations and assurances mentioned in the recitals, the licensor hereby agrees to give to the licensee, and the licensee agrees to take from the licensor a bare, revocable, non-exclusive, non-transferable, non-assignable, and non-heritable license to use the said Western Block as described in Schedule 1B attached hereto, on a restricted and personal permission basis, on leave and license basis, for use of temporary residential purposes of the licensee only. So everything is temporary. It is not heritable. So if tomorrow this gentleman's Samrat data expires, God forbid, his legal heir cannot come and seek specific performance of this, my lord, legal license agreement. Then, my lord, lordship, kindly come, my lord, to page 70, clause number 9. Licenses assurances. Lordship has seen it, my lord. There, my lord, I am relying on subclause 2. Clause 9, the licenses assurance. Kindly see, my lord, subclause 2. That the licensee agrees and confirms that notwithstanding this agreement of leave and license, the exclusive and judicial possession of the said Western Block shall always remain with the licensor. The licensor has handed over the duplicate keys of the said Western Block, and the licensee agrees not to change the said lock at any time whereafter. This agreement is so strictly worded that even my lord, the licensor, that is, my lord, the predecessor in interest of the defendants, that is the opposite parties, he has retained the original keys with himself, original house keys with himself, and he has given a duplicate keys to them. And, my lord, the licensor says, and the licensee has agreed not even to change the said law. They cannot even change the law also. If I could have perceived the situation, if it would have been the intention of, my lord, transferring this property between the parties by way of lease, these clauses would not have been there. So therefore, it is very restricted. Only limited use. And the other agreements which lordship will see, well, these are all similar and identical agreements. One lordship will find at page 75, the next agreement, page 75, where, my lord, the clauses are identical. Identical clauses. Then the third agreement lordship will find at page 82, that is also identical. The fourth agreement, of course, copies of these agreements we have produced before the trial court. We could have denied simply. And no, there is no lease. You are making a false statement, you prove how there is lease. We had shown our bona fide before the learned trial court by producing these documents. What was the occasion for us to produce these documents before the trial court? We could have remained silent. It is they who have alleged willful, my lord, disobedience of that an interim injunction order dated 5/4/2021, where only 2 embargoes were casted upon by the learned trial court on the defendants. Number 1, that you cannot transfer. Number 2, you cannot alienate. Meaning thereby you cannot transfer under the provisions of Transfer of Property Act. Transfer has to be in accordance with law. Now there is no transfer in view of the recitals laid down in this, my lord, legal license agreement. So we are confident enough that this is not a lease agreement. So let us produce it before the court. It is not an issue of taking any risk even, my lord. We have shown our bona fide. Because Order 39 Rule 2A proceedings are quasi-criminal in nature. So I have to be quite bona fide before the court. I cannot play any hide and seek. Nonetheless, I could have remained silent, which I didn't. And all these agreements are, my lord, identical. Then the fourth.
Why you are afraid of producing the original agreements before the court?
Yes, that is not even required. That is what the learned trial court. I'm supporting it. No, I'm coming to it, my lord. Then the fourth agreement, lordship will kindly see at page 96. It is not going to serve any purpose. Page 96 is the, my lord, fifth agreement. These are all identical agreements.
No, that's all right.
Yes,
There is no doubt about it.
yes, now kindly see, my lord, the impugn order, the order impugn hearing. That starts, my lord, from page 72 onwards. Lordship may kindly come, my lord, to page 175. the last but second page of the civil division application.
Yes.
Page 175, my lord. I'm reading, my lord, from the second paragraph. Case record reveals that on 1/7/2023, Lordship got it, my lord.
Got
And
it.
so obliged, my lord. Case record reveals that on 1/7/2023, office filed a written objection against the application of petitioner filed under Order 39 Rule 2A and 7, read with Section 151 of CPC. On the same date, the office filed a list of documents which are the same documents the petitioner has paid for passing order for their production. All the documents in the list of office are the documents of leave and license agreement of different dates ensued since 2017. Lordship has seen that first agreement of 2007, that is prior to the institution of title suit number 7 of 2021 and continuation thereof till 1/6/2022. In his argument, Mr. So-and-so for the office has rightly pointed out that the petitioner has incorrectly referred to the license agreements as lease agreements. Perusal of the documents makes it crystal clear that neither of the documents listed by the office refers to granting lease of any property. The operative part of the order dated 5/4/2021 that the petitioner's prayer for ad interim temporary injunction restraining the office from transferring and or alienating the properties described in Schedule B5 to the plain till disposal of injunction application in Ms. case 9 of 2022, 1 is allowed. Also explicitly speaks that the petitioners did not have prayer for restraining office for granting license. This is the finding. But with all respect, can this honorable court substitute the finding, my lord, of the learned trial court?
No, I am not saying that I will substitute
My
my
lord.
finding with
Yes,
that
my
of the trial court.
Yes, my lord, then further, my lord, the last two paragraphs.
My only question is why you are afraid to produce the original documents
No, it
before
is
the
not a
court?
question of being afraid, whether legally I am bound to produce it. If I can satisfy your lordship that I am not legally bound to produce it, better ends there. Then the last paragraph, my lord, last paragraph, may I read it, my lord?
No.
The entire discussion.
To justify the stand taken by you before the trial court,
Yeah.
why you are not bound to produce the documents?
No, because there is no violation apparently. What they will justify?
The violation is secondary thing and the
No, the proceedings.
production of the documents are another thing.
Exactly. Therefore, the lease before the learned trial court below is under the provisions of Order 39 Rule 2A, whether there is violation. And when there can be violation, my lord? If I had transferred or alienated.
No, the court has to ascertain whether the documents or when the documents were executed, when the agreements were executed.
Absolutely.
So there is allegation that it is a manipulated document executed subsequently.
Whatever it is.
Yes.
But the document.
So to ascertain that question of whether the production of original document is not required, are you not bound to produce the original document?
No, I am bound to produce the original documents if it is proved on record. Trial court. If it is proved on record before the trial court that these are lease agreements, then only, my lord, because I am required to produce the documents in order to enable the learned trial court below, or for that matter before this honorable court, my lord, that I have effected, my lord, transfer of property by way of lease. This is the complaint coming from their side. What is their complaint? Their allegation. Their allegation is that, my lord, I have entered into a lease agreement. Unless and until there is a lease, there only, my lord, in case of lease, there can be transferred. If it is leave and license, it is not transferred. It is not transferred. So if I can prove primarily, prima facie, that it is a leave and license agreement, they will have to produce other materials before the court. Why should I produce? Why should I produce? Because these are not lease agreements. Only if these are lease agreements, then only, my lord, the issue of violation will come. Because production of document, what has necessitated me to produce that document? Because there is a violation proceeding which is hanging over me. They are alleging that despite of the ad interim or injunction or order dated my lord 5/4/2021, I have transferred the property by way of lease. They have not spelled out in their agreement that, my lord, in their petition, that I have executed lease and license agreement. They have spelled out categorically that I have leased out that property. I said that no, I have not leased out that property. In fact, I have only entered into leave and license agreement. These are the leave and license agreement. I have shown it before the court. The courts come to a satisfaction. What more is required, my lord? Court comes to a satisfaction on facts. What more is required? What logical conclusion will they derive, my lord, on production of originals when I have sufficiently proved before the trial court as well as in the present proceedings that these are not lease agreements? Now I will be relying on the Supreme Court decision, my lord, in order to find out whether the document is, my lord, a lease agreement or leave and license agreement. So therefore, at the initial stage of my submission, I have made a categorical submission before your lordship that if, my lord, if it is proved that these are lease agreements, then I am in trouble, deep trouble. But if it is proved that these are not, my lord, lease agreements, rather these are leave and license agreement, then I am protected. Then the burden shifts to them. I have not made any allegation. It is they who have made the allegation against me that I have executed lease
No,
agreement.
there is also allegation that these documents were executed subsequently.
Maybe subsequently, whatever it is, but what is the tenor of this document? If I may execute anything, but that is to be linked. That is to be linked to that order dated 5/4/2021. And what that order dated 5/4/2021 says, that I am restrained from transferring or alienating that property. I may execute 100 different types of documents, lakhs of documents. Where is the restriction? They will have to link it. And it has to be proved, my lord, with all the rules of preponderance of probability. And the rules of preponderance of probability does not suggest that, my lord, this is a lease agreement. Production will only come when, my lord, it is proof, my lord, or it is established that these are lease agreements. Then only
Then how do you justify the other allegation made by them that these are the documents executed subsequently? Unless and until you produce the original documents before the court.
No, it is admitted. We have admitted that we have executed it subsequently. We have not denied anything. Therefore, my respectful submission, even if it is taken on record, that is the admitted position. Therefore, my lord, what I am submitting till now, my lord, I am submitting on the admitted position available on record. I have admitted that due to COVID, I could not, my lord, execute the documents. So therefore, I have, my lord, for record purpose, there has to be a continuity. And when this gentleman, this, my lord, Samrat Deka, the licensee, when he has no objection, who are they to question? They are only interested with the partition of the property. They are interested in two aspects of the matter right now. Number one, partition of the property, and number two, whether to, my lord, confine me within the parameters of Order 39 Rule 2A. Now, in order to confine me within the parameters of Order 39 Rule 2A, which is in the nature of a quasi-criminal proceeding, they have stated that I have clearly violated the order dated 5/4/2021 by entering into lease agreement. They did not say that I have executed leave and license agreement. There is no sincere efforts on their part to make an inquiry. Therefore, this application has come after 1 year. This application has come after 1 year. Initial order.
If the violation take place subsequently, then are they not entitled to file application even after 2 years or 3 years?
So, therefore, my lord, this order has attained finality. So therefore, that injunction order has attained finality. My lord, on
subsequently the violation taken place.
Definitely. Definitely.
And are they not entitled to approach the court
Yes,
on
definitely.
that count?
Yes, they can, but till my lord, that ad interim order subsists. And that ad interim injunction, therefore I had drawn my lord's attention to the subsequent order, whereby that miscase has been disposed of. Now
No,
injunction is
maybe,
made
but
absolute.
that ad interim order was made absolute.
Yes, that is made absolute. And till that is made absolute in the year 2023. So therefore, from that, the order is also here, my lord, that is made absolute, my lord, on.
No, you have shown me
Yes,
that order.
my lord, yes, that is order dated 22/3/2023. So from 5/4/2021 till 24, they have every right.
title suit is still pending before the trial
Yes,
court.
no preliminary decree as on now, as of
Yes.
today, no preliminary decree. No preliminary.
Then where
decree.
is the bar in approaching the court for violation?
Definitely there is no bar, but
Then
no, from 5/4/2021
no,
till
you are submitting that since the miscase has already been disposed of, they cannot approach the court.
No, they can approach, but they have not approached the court alleging violation of the subsequent order. They have approached the court alleging violation, my lord, of the order dated 5/4/2021.
Maybe
So, yes,
that ad interim order and the order making absolute of the same.
yes.
They're same. Then
So they have every right to make an application. I cannot prevent them, but in making that
anyway, you refer to Supreme Court judgment. Let's
Yes.
see.
Now I am relying, my lord, I have furnished one copy, my lord, this 2012-11 SCC 713.
Relevant paragraph.
11 paragraph, my lord, 15, 16 and 17. 2012-11 SCC. Here, my lord, iron
So
couple
it relates to this lease and license.
Yes, absolutely. And Aryan Kapoor has been relied. Aryan Kapoor is relied upon by my petitioners. Kindly see, my lord. I am reading paragraph 15, my lord. The principal question to be considered is as to whether the document of allotment of land dated 6/5/1994 was in any way a lease or a license. As far as the lease is concerned, Section 105 of the Transfer of Property Act defines it as follows. Section 105, lease defined. A lease of immovable property is a transfer of a right to enjoy such property made for certain time, express or implied, or in perpetuity, in consideration of a price paid or promise, or of money, a share of crop, service, or any other thing of value to be rendered periodically or on specified occasions to the transferor by the transferee who accepts the transfer on such terms. Lessor, lessee, premium, and rent defined. The transferor is called the lessor, the transferee is called the lessee, the price is called the premium, and the money, share, service, or other thing to be so rendered is called the rent. As far as the license is concerned, the same is defined under Section 52 of the Easements Act 1882 as follows. 52 license defined. Where one person grants to another or to a definite number of other persons a right to do or continue to do in or upon the immovable property of the grantor something which would, in absence of such right, be unlawful, and such right does not amount to a easement or an interest in the property, the right is called a license. From these two definitions, it is clear that a lease is not a mere contract, but envisages and transfers an interest in the demised property, creating a right in favor of the lessee in rem. Lordship will mark this. Creating a right in the favor of the lessee in rem. And what, my lord, this legal license agreement has spelled out, that it is only, my lord, not which expression does not include the heirs and successors. As against, a license only makes an action unlawful, which without it would be unlawful, but does not transfer any interest in favor of the licensee in respect of the property. Then paragraph 16, my lord. The issue concerning the distinction between lease and license came up for consideration before this court in Associated Hotels of India Limited versus R.N. Kapoor. In paragraph 27, it is stated as follows. There is a marked distinction between a lease and a license. Section 105 of the Transfer of Property Act defines a lease of immovable property as a transfer of a right to enjoy such property made for a certain time in consideration of a price paid or promised. Under Section 108 of the said Act, the leasee is entitled to be put in possession of the property. A lease is therefore a transfer of an interest in land. The interest transferred is called the leasehold interest. The lessor parts with his right to enjoy the property during the term of the lease, and it follows from it that the lessee gets the right to the exclusion of the lessor. Thereafter, the learned does refer to the definition of license and observed as follows. Under the aforesaid section, if a document gives only a right to use the property in a particular way or under certain terms while remain in possession and control of the owner thereof, it will be a license. The legal position therefore continues to be with the owner of the property, but the licensee is permitted to make use of the premises for a particular purpose. But for the permission, his occupation would be unlawful. It does not create in his favor any estate or interest in the property. There is therefore clear distinction between the two concepts. The dividing line is clear, though sometimes it becomes very thin or even blurred. Then, my lord, paragraph 17. The following propositions may therefore be taken as well established. Number one, to ascertain whether a document creates a license or lease, the substance of the document must be preferred to the form. The real test is the intention of the parties, whether they intended to create a lease or a license. Then number three, if the document creates an interest in the property, it is a lease. But if it only permits another to make use of the property of which the legal possession continues with the owner, it is a license. And number four, if under the document, a party gets exclusive possession of the property, prima facie he is considered to be a tenant, but circumstances may be established which negative the intention to create a lease. And the dictum of the Honorable Apex Court, in my respectful submission, is well founded, my lord, in the face of the legal license agreement itself. That is my respectful submission. And so therefore, these documents being legal license documents, my lord, agreement, whereby and whereunder I have not transferred the property in question to a third party, there is no question of violation. And of course, madam, that violation petition is still alive. That violation petition is still alive. That violation petition has not been finally disposed of. What has been disposed of is their application whereby they have, madam, sought, they have called for the original documents, copies of which are available in court. Trial court comes to a conclusion that these are legal license agreements. If it is a legal license agreement, it is not associated with the lease in question. Facts in issue.
Yes, Mr. Dekka.
Yes, my lord, I'll make 4 quick points, my lord. My lord, first of all, the issues which my learned friend has raised, my lord. Lord, at this juncture, this court is not called upon to decide whether there has actually been a violation or not. So this court need not really go into the interpretation of the agreement to find out whether it's actually a license or a lease. That is something which the trial court has to do after the originals come on record in the proceeding for violation. Because like my friend has rightly pointed out, it's a quasi criminal proceeding, evidence has to be laid. So the question today only is whether they should produce the documents or not. Now, documents, copies of the documents have already been produced. It is they who are relying on those documents. But the moment we point out discrepancies and say that please produce the genuine, they are saying no, you be satisfied with the copies. You establish from the copies that it is actually a lease, only then we will produce the originals. That is the precise argument, if I have understood it correctly. Now, Lord, secondly, our contention is that these documents are sham and manufactured documents. These are backdated documents camouflaged as license agreements so as to wriggle out of the violation proceeding. Though pain has been taken to read out the clauses very carefully, my lord, unless the genuineness or the validity of these documents are established, my lord, then reading the clauses of the agreement as if they are the
No,
gospel.
Mr. Deca,
My lord.
they have admitted that those documents were executed subsequently.
So are they also forged, my lord? Because I had made two allegations. That number one, the signatures are also not genuine. Number two, these are backdated. My lord, the admission is not very clear, but we can infer from their statement made in paragraph 5 of the written objection that they are to some extent admitting. Now, when were these documents actually manufactured, my lord, if they are admitting to it? It could be post 2023, that is after the final order of injunction also. It could be after we file the violation application also. Now, if these things come
No,
on.
maybe they have admitted that the documents were executed subsequently.
Now, my lord, even then, my lord, what would bother us is the finding of the learned trial court. Because learned trial court says these could be executed before or after the injunction, but these are leave and license agreements only. My lord.
Yes.
Now, that is why.
If by executing such document they have not violated the execution order, this injunction order, then.
Well, that decision has already been taken by the trial court in the opinion in the order itself. He said the trial court says that these perusal of the document makes it clear that neither documents listed by the OPs refer to granting of any leave. The operative part of the order also does not restrict them. So virtually, he's decided the violation application. That because these documents are license agreements, therefore there has been no violation, because what is restricted by the order of 5421 is only alienation and transfer. Now, my lord, the order should speak for itself. If the trial court did not even venture into the clauses which have been read out today, it merely goes by the heading. These are license agreements, therefore no violation. And because 5321 doesn't really restrict license.
No, Mr. Barposari has already read out the contents of the document.
No.
Do you have any doubt about it?
Yes, my lord. Yes, my lord.
How?
No. I am saying that these documents are manufactured documents. Now, if there is truth in my contention, then to read this document so carefully and to come to a conclusion that this is not leave and license, this is not lease and this is leave and license, will not be sufficient, because I am saying these documents are sham. And because they are sham, there is discrepancy in the serial numbers. Because they are sham because they are backdated. Now, in that fashion, they can produce any document and say that this is not a lease. So if the very genuineness of the documents are in question, to read the clauses of the agreement and to come to a conclusion this is actually license, will, in my respectful submission, not be the correct course to adopt, my lord. Because first of all, let them establish that these documents are genuine and these are valid documents. Then probably the court will venture into the clauses to figure out what was the real intention of the parties. No, not my. There is that I bow down. We were actually clueless. We actually did not know what has been transpiring. Therefore, we had said we have seen new people in the house and we are denied access. Therefore, we filed the application, and it is they who produce the documents. The only thing where I would differ is it was not a bona fide action. It was actually a strategic blunder, because they thought the serial numbers would not be checked. And they thought that we produce these documents and show that these are license agreements. Number two, secondly, these are executed prior to 2021. So the moment they did that, my lord, they sort of dug their own grave, and now they are shying away from producing the original. Now they are saying that copies, these documents they have only produced, but they for some reason are shying away from producing the original, because production of the original may throw light not just on the fact of backdating, my lord, but also on the fact of forgery, because retouch has signatures are also different. If your lordship sees the page 82, if your lordship takes up for a moment.
Yes.
Compared to. Page 82, your lordship will find the signature. It's, you can't really make out, but 89, page 89, if your lordship sees,
Mm.
Rita Choliha is very clear.
Mm. In 82, it is signed as Radhika Soleha.
No, Manoj, 80, no, Manoj, yes.
82,
82, there are three signatures.
yes.
The three
One is
signatures.
Radhika Soleha.
One, no, Manoj, the two licensors at page 88, if your lordship sees.
Mm.
Rita Choliha, your lordship has seen at page 88.
Mm.
And now at page 95, if your lordship sees.
No, 88, it is short signature.
That's she signed short signatures everywhere, Manoj. These subsequent deeds are, Manoj, now, of course, there has to be an examination of the signatures, Manoj. My lord will kindly appreciate, they can come and show any document. And then they want to take up a defense, then look, these are even license agreement. The moment serious allegations come in, they will say that no, these documents are not irrelevant. We have only filed these documents, but these are not relevant for adjudication. This is blowing, approbating and reprobating. They file these documents in the written objection to say that look at these documents, these are relevant documents that will prove that we have not violated. And now they're saying that these are not even relevant, therefore we will not produce the originals.
Mm. Okay, in the judgment referred by you have relied upon which paragraph?
Malord, associated hotels would be paragraph 28, Malord. 28 mainly. One more judgment, just one paragraph of that judgment I'll just quickly place, Malord. Paragraph 8 and 9, if your lordship sees. Because here also, sometimes the parties may choose to style it as a license deed, but it is the duty of the court to call out whether what is the real intention. Paragraph 8 and 9 for a moment, Manoj.
No, that proposition is already laid down in
But
the judgment
here-
referred by him.
No, Manoj, I'll just read 8 and 9 when it is styled as a license. Because my friend has read out that this is a license.
No. In the judgment referred by him,
Yes.
the proposition has been laid
Proposition
down.
is laid out, and further, Manoj, conduct is also to be seen. And Manoj, if I may, just two sentences from para 8, Manoj. The crucial issue for determination is as to whether there is a lease or license existing between the parties. Though a deed of license may have been executed, it is open for the parties to the document to show that the relationship which was agreed upon by the parties and was really intended to be brought into existence was that of a landlord-tenant, though it was outwardly styled as a deed of license to act as a camouflage on the rent control legislation. Now, paragraph 9, Manoj, again. A few principles are well settled. User of the terms lease or license, lessor or licensor, rent or license fee are not themselves decisive of the nature of the right created by the document. An effort should be made to find out whether the deed confers a right to possess exclusively coupled with transfer of a right to enjoy the property. What has been parted with is merely a right to use the property, and while the possession is retained by the owner, the conduct of the parties before and after the creation of the relationship is of relevance for finding out their intention. So the lease, the document may say it's a license. They may be referred to as licensor and licensee. There could be definitions regarding under 52, but it could all be a camouflage. And just because that document says so does not really mean that that is decisive. The use of such terms alone are not decisive. So all these aspects the learned court will definitely consider while taking up the violation application, my lord. But as of now, if they have actually done something which have alleged, then it's a case of section 190 IPC. We may even move an application under the new CRPC, my lord, for drawing up a proceeding. Well, for that, the records have to come. So, my lord, given all of this, the other questions, your lordship may leave it open. Tomorrow, the trial court might as well again come to the same decision that it's actually a license and not a lease. You know. However, the person concerned is residing there. I am not aware of a license where a immovable property is given out for residential purposes. You know. Because the agreement, on the other hand, says residence. You know. It qualifies the word residence with the word temporary. That itself will not change its character from a license or from a lease to a license. You know. So at this juncture, my lord, the ground on which the trial court has rejected is fallacious, and so long as the reasoning is bad, my lord can always strike down that order. And
Okay. We'll pause the order. Pause the order. Even on. We'll pause the order and upload it.
no,
Pending item 5.
Whether revision will lie or appeal will lie.
Lordship, appeal lies, but
Appeal lies. You withdraw this petition and file appeal then.
then I
Mr.
may be
A.R.
allowed to
Agarwala,
give the-
learned counsel for the petitioner, submits that he may be permitted to withdraw this petition and to
Honorable
approach this
Bhatti
court
also-
again by filing appropriate petition. That is accordingly allowed.
Lordship,
This-
I may kindly be returned this certificate to copies of my documents certificate.
This civil revision petition dispose of on withdrawal. However, liberty will remain with the petitioner to approach this court again by filing appropriate petition. Rest is directed to return the certified copy of the documents to Mr. Agarwala.
Item 17.
I'm supposed to produce some documents today. But
Yes.
I have received the documents, but those are not legible.
Yes.
I have instructed my client to send the legible copies, Lordship. It will be received by tomorrow, Lordship. So
Okay,
can it
then
be
on
next
Tuesday
Friday?
or
Next Friday.
Friday?
On Friday, Lordship, Friday.
Okay. On the pair being made by Mr. D. Das, learned counsel for the appellant. Rest is list the matter on Friday.
Lordship.
8 November. Item 18.
Lordship, it is appeal for enhancement, Lordship. On 2 count, I'm preferring this appeal also. The disability certificate, exhibit 6, which says that there's disability of 45 up to 45% also. That was not considered. And amount of interest which was directed to be given by the learned tribunal also, it was from the date of filing the evidence also. In deviation of the normal practice of filing the claim petition also. And the reasoning that has been given by the learned tribunal lordship in not considering the disability certificate that has been reflected at page 26, lordship. They say that even though the board stated that the claimant could not walk without support, but there is no evidence on record to show indicating any such disability. But the board has been was duly.
No, if the board has given the certificate, then what more is
Yes,
required?
lordship. That was not understood.
That is, one is this disability certificate and the other is?
Other is the amount of rate of interest, lordship. That was directed.
What was the rate of interest?
Rate of interest was lordship. We are not questioning the rate of interest. We are
Then?
questioning the time, the effect of rate of interest. Lordship.
From which
From
date?
the date of filing the evidence of the claimant, lordship. It is normally from the date of filing the claim petition, lordship.
Okay.
Lordship.
Heard Mr. D. Das, learned counsel for the appellant. This appeal under the 3 of the MB Act is directed against the judgment and award dated 21/6/2024 passed by the learned member MSCT Golpara in MSC case number 71 of 20 2020. It is to be noted here that by the impugned judgment and award dated so and so, the learned member MSCT Golpara has directed the respondent number 1 to pay a sum of rupees 1,20,428 being the compensation to the appellant. Mr. Didas, learned counsel for the appellant, submits that this claim petition is preferred for enhancement of the awarded amount on 2 counts. Firstly, Mr. Das submits that while assessing the compensation, the learned tribunal has not considered the disability certificate issued by the board. And secondly, Mr. Das submits that the learned tribunal has awarded the rate of interest from the date of filing of the evidence, not from the date of filing of the claim petition. Be that as it may, at this stage, admit the appeal, notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record from the learned member, learned tribunal, MSCT Golpara, leaves the matter after 4 weeks.
I'm deeply okay.
Item number 19.
May please your lordship. Lordship, this is appeal for against the quantum lordship.
For Mr. Coletta, learned counsel for the appellant. This appeal under section 173 MB Act is directed against the judgment and award 24. Caused by the learned member MSCT number 3. Party in MSC case number 1898 of 2017. It is to be noted here that by the impugned judgment and award dated so and so, the learned tribunal has directed the appellant herein to pay a sum of rupees.
With lordship, 15,81,000.
Where it is mentioned,
Page number 27.
15,81,000. Being the compensation and further provided that the amount shall carry interest at the rate of rupees 9% per annum from the date of filing the claim petition. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and award dated so and so. Let notice be issued to the respondents, returnable in 4 weeks. Step be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record from the learned tribunal. Place the matter after 4 weeks.
Perhaps lordship, respond number 1 to 8.
I'm appealed.
They have appealed.
1 to 5.
How about no formal notice is required to be issued to respondent number 1 to 8 since Mr. Bhattacharya learned counsel for the respondent.
1 to 5.
1 to 5
and 8.
1 to 5 and 8.
And 6 has expired in the meantime.
Okay. Mr. Bhattacharya further submits that the respondent number 6 already suffered demise. So, abated.
Lordship,
No, the other
remains lordship.
the legal are represented. Already there in the part proceeding.
She was the daughter of the deceased person.
Mother is already there.
Acha.
Other family
And
members are there.
that she has already been represented by respondent number
Other respondent.
by other respondents. This is IFO stay,
Stay lordship.
so 50%.
I know at this stage may not be because a talk of compromise is going on between the parties. It will soon be,
Okay,
for the time being, lordship may not take up this.
okay.
I agree.
will not pass any order.
Item 20,
Please.
Please, my lord.
Yes.
Lordship, here I am having awarded by the death of my younger brother, and my mother was also party at the time of filing the claim. It only awarded only medical expenditure only. Lordship, this is death case, Lordship. And holding that I am not dependent, but there are ample evidence that I am dependent on my deceased brother, Lordship. The position.
Okay. Learned counsel for the appellant. This appeal under section 173 of the MB Act is directed against the judgment and award dated 10/7/2024, passed by the learned member MST. Number 3, Kamrup M. Guwahati, MSC case number 903 of 2021. It is to be noted here that by the judgment and award dated so and so, the learned tribunal has directed the respondent number 1 to pay a sum of rupees 3,46,821, being the
Medical expenditure.
being the compensation. Being the compensation. Here is the memo of appeal and the grounds mentioned therein. Admit, issue notice to the respondents returnable in 4 weeks, step be taken by registered post with AD and also by usual process within a week from today. Rest shall call for the record from the learned tribunal.
item 21,
See, this is a fresh appeal against the Lordship judgment passed in case 16, Lordship.
This is for enhancement.
Lordship, no, Lordship, I have the claim petition has been dismissed by the learned tribunal.
Why?
The learned tribunal below has dismissed the petition mainly for 2-3 grounds, Lordship. Lordship, may kindly see the page of 19, Lordship. Reasoning number 9, Lordship. Paragraph number 9 of the judgment, Lordship. During trial, the claimant, Confusion Hazra, in his deposition stated that while he was sitting in the side of the road, the accident took place. It appears to me that there is a contradiction in the statement of the claimant. In the claim petition, it is stated that it was the father of the claimant who sustained injury. That was a apocryphal mistake in the petition, Lordship. But in the evidence in sheet, the claimant submitted that he himself sustained injury. The claimant exhibit FIR as exhibit 1 and the claimant also exhibited.
Okay, we will admit it. Pardon, Mr.
J. Abbas.
J. Abbas, learned counsel for the appellant. This appeal under section 173 and the act is directed against the judgment and order dated 29/3/2024, passed by the learned member MSCT Sirang Kazolgaon in MSC, within bracket injury case number 05 of 2020. It is to be noted here that by the impugned judgment and order dated so and so, the learned member MSCT Sirang Kazolgaon has appellant. Admit and peruse the memo of appeal and the grounds mentioned therein. And also peruse the impugned judgment and order dated so and so. Admit, let notice be issued to the respondent, returnable in 4 weeks, that be taken by registered post with AD and also by usual process within a week from today. Basis shall call for the record from the learned tribunal. List the matter after 4 weeks.
Deeply honored.
22,
Appeal for enhancement, Lordship, filed by the claimant, Lordship. This injury case, Lordship, disability was 70%, but learned tribunal has taken it as 50%, Lordship. So at this stage, notice will go and
Percentage of disability was 60?
70%.
70%.
Lordship, amputation was there, and she was a beautician, and income was also, as per government guideline, it was 477, Lordship, but honorable tribunal has taken it as 10,000 per month, Lordship. So on that count, we have filed this appeal for enhancement, Lordship.
No, court can assess the functional disability lower than the disability prescribed in the disability certificate.
Lordship.
So what wrong with the tribunal?
Lordship, as per board, it was assessed as 70% disability.
Maybe,
And
but
impeachment,
that is not the final. On the basis of that disability certificate, court can assess the functional disability of the person.
Lordship.
That may not be same with the disability assessed by the board.
Lordship. Sometimes maybe that 70% may 100% also, but regarding income, Lordship.
Yes, not
So
regarding income, regarding this functional disability.
Lordship. She is a beautician, so she was amputated. And sir, Lordship, income was also taken lesser, Lordship.
Have you produced any document regarding income?
Lordship, as per government guideline, it was taken as skilled labor, so 477 rupees per month, Lordship, per day, Lordship. And tribunal has taken it at 10,000 per month.
No, without any document, the learned tribunal has
No, Lordship, we have
fixed
produced
the
that.
notional income.
Lordship, we have produced that beautician certificate from that concern.
Certificate may be court may court may no, it relates to her avocation, not to her income.
Lordship.
Then
Lordship, she is a beautician and we have taken.
anyway, addresses will admit the
Lordship, LCR may call for.
notice. Pardon me, sir.
KK Doctor.
KK.
Lordship.
Dr. Learned Counsel for the appellant. This appeal under section 173 MB Act is directed against the judgment and award dated
6/24.
The learned member, MSCT number 2, Kamrup and Guwahati, MSC case number 362 of 2018. It is to be noted here that by the impugned judgment and award dated so and so, the learned member, MSCT number 2, Kamrup Guwahati, has directed the respondent number 3 to pay a sum of rupees
33 lakhs 8,560.
Page number
Lordship. Award.
33 lakhs 8,560. And further provided that a sum of no, further provided that the aforesaid amount will carry interest at the rate of 9%. From which date?
From the date of filing of the claim petition.
From the date of filing of the claim petition till realization.
Lordship.
Whereas the memo of appeal and the grounds mentioned therein, and the impugned judgment and award dated so and so. Admit. Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post with AD and also by result process, which we have from today. Registrar shall call for the record from the learned tribunal, list the matter for 4 weeks.
23.
Lordship.
30 बोलने आ गए.
May please be minute. But this appeal is only real consortium has been awarded to me. And 920 rupees is medical expenditure of my for my disease birth. So appeal में kindly wait me.
Third Mr. A.R. Agarwala, learned counsel for the appellant. 73 of the MBA is directed against the judgment and award dated 11/9/2024. Passed by the learned member, MSCT number 3, Kamrup and 810 of 2019. Is to be noted here that by the impugned judgment and award dated so and so, the learned number 3, Kamrup Guwahati, has directed the respondent National Insurance Company to pay a sum of rupees 44,920 only. And further provided that the aforesaid amount will carry interest at the rate of 9% per annum from the date of filing of the claim petition. Peruse the memo of appeal and the grounds mentioned therein and the impugn judgment and award dated so and so. Let notice be issued to the, no, admit, let notice be issued to the respondent as returnable in 4 weeks. That be taken by receipt also with ADN also by usual process, returnable from today. Rest shall call for the record from the learned tribunal. Place the matter after 4 weeks.
So items for hearing under order 41, rule to CPC item 24.
Hello, the plaintiff filed number 1 was the made party. But his other brothers now they also filed a counter claim along with the defendant number 1. The learned Munshi decreed the suit and also dismissed the counter claim. Against both the order separate appeal has been filed, one for dismissal of the counter claim and another for decree of the suit. The learned appellate court will also dismiss both the appeal. And against that, I approach this noble court, my lord. You will also kindly see that here only fact is this, like there is a some plot of land belongs to his father. After death of his father, the portion is to get equal share. But subsequently, what happened, my lord, that defendant number 1, he got converted the periodic land to the partial land, measuring 2 biga 19 less or something. But he is only entitled to get 4 kata 19 letters. Now, out of 4 kata 19, he is pulled out.
Where is the substantial question of law?
Page 11.
Page 11 is not part of the memo of appeal.
No, the next. Is the those are the count.
You see the section subsection 3 to section 100.
Yes.
CPC. You have to mention the substantial question of law in the memo of appeal.
Yes, my lord. Paragraph page 11, my lord.
11 is not part of the memo of appeal.
It is the ground. I give the ground is separate. And
You see the section
yes,
first.
I see.
Hmm.
I have seen
Same.
it.
Are you satisfying the requirement?
But sometimes in this case, I actually ground is not necessary, but I have both mentioned in both ground and
No,
subsequent
necessary, unnecessary, that is a
Yes.
different matter. But are you satisfying the requirement of subsection 3 to section
Yes.
100?
You also kindly see page 5.
Hmm.
The appellant prepared this memorandum on the following grounds and
Those are
subsequent
grounds,
question.
those are not substantial question of law.
And grounds and subsequent question of law. I give
You
the
file amended memo of appeal incorporating the substantial question of law in the memo of appeal. What, Mr. J. Ahmed, learned counsel for the appellant. List the matter on next week.
On 13th,
For that.
8.
Eight.
11.
So as to enable Mr. Ahmed to file amended memo of appeal incorporating the substantial question of law.
Item 25.
This is same.
Yeah, fine.
26.
May I please, Your Lordship?
Hmm.
My lord, the appellant before your lordship is has undertaken the work of repairing and servicing of vehicles
Hmm.
of the respondent company, my lord. and an account was opened that whenever, my lord, the servicing will be done to their vehicles, then it will be kept in the ledger. And my lord, they started paying lump sum amount. And in that way, my lord, as on 1/4/2014, there was outstanding amount of rupees 6,39,126.65, my lord. Thereafter, in the year 2014-15 itself, certain materials in the form of motor parts, my lord, was supplied to the respondent, my lord, and it was amounted to 7,80,966. Out of those amounts, my lord, on 25/6/2014, 2 lakhs rupees was paid. 2 lakhs rupees was paid and it was deducted. Thereafter, from 1/4/2015, my lord, another amount of rupees 12,20,992.65 accrued. And as against that, my lord, they had paid rupees 3 lakhs on 2/4/2016. My lord, the learned trial court has hold that it was a continuing account, my lord. Always the money was paid in lump sum, not as per the bill or not as per the work done, my lord. So it was a continuing account. It was a continuing account. My lord, the learned trial court has hold.
Mr. Sattar,
Yes, my lord.
second appeal is admissible only on the point of substantial question of law.
Yes,
the question you have suggested herein are question of facts.
No, my lord, question number page number 7, only one question, my lord. Whether in a continuing account, amount can be said to be time barred. It is the only question, my lord.
Question of fact.
No, it is not a question of fact, my lord. Because, my lord, if your lordship can peruse this, the page number 7, 5. For that, the substantial question of law is whether the transaction between the plaintiff and the defendants was of a continuous nature and process, and all the transactions made with the defendant by the plaintiff maintained in the electronic devices, including the lump sum payment from time to time, would be barred under the law of limitation. This cannot be, my lord, said to be a question of fact. It is a question of law, my lord. Only one substantial question. Other is correlated to that, my lord. Work was being done to their satisfaction. They used to pay the amount and it was getting detected out of the total amount, my lord. So in that way, the account was continuing on. And moreover, my lord, they never contested though the service was made, they never contested the suit. And they never contested the appeal also. It was ex parte, my lord. But then even the learned trial court, as well as the first appellate court, my lord, have hold that the amount which were calculated as of 1/4/2014 is barred. If I can
What is that finding?
Yeah, my lord, if I can take your lordship to the judgment dated 5/4/2019, and more particularly, my lord, page number 15. Page number 15, my lord. In the page number 15 order, in the operative parts, my lord. Money suit number 320 of 2017 is partly decreed and disposed of ex parte with cost. The defendant shall pay the outstanding amount of rupees 7,76,320 to the plaintiff inclusive of interest at the rate of 21% per month from the date of filing of the suit till the date of decree, and shall pay interest on the decretal amount at the rate of 6% per annum and so for realization of the defendant shall also pay the cost of the suit to the plaintiff. Accordingly, this was, my lord, partly decreed. Holding that.
And where is the finding of the first appellate court?
First appellate court, my lord, your lordship will be pleased to see that at page number 25. Last paragraph, my lord. In this context, para 15, my lord. In this context, it is also pertinent to refer to section 25(3) of the Indian Contract Act, which provides that an agreement made without consideration is void unless it is a promise made in writing and signed by the person to be charged therewith, or by his agent generally or especially authorized in that behalf, to pay wholly or in part a debt of which the creditor might have enforced payment but for the law for the limitation of the suits. It means that a promise made in writing and signed by the debtor to pay a time-barred debt is a valid contract. However, in the present case, no such written promise was made by the respondent defendant to pay the time-barred debt. Rather, the first appellate court is insisting that there ought to have been agreement to pay the time-barred debt. But whereas, my lord, the respondent has already paid thrice the amount to me during the course of the transaction, my lord, and that too in the form of lump sum. In view of the above, this court doesn't find any illegality or error in the observation made by the learned trial court in paragraph number 11 of the impugned judgment that the outstanding amount of INR 6,39,126.65 as on 1/4/2014 is a time bar. The impugned judgment does not warrant any interference of this court. This is the final order. And my submission before your lordship is, as it was a continuing transaction, out of which lump sum amount were paid, there no any written argument or knitted agreement is required, because the payment itself goes on to continue with the continuation of the services, my lord. It is just like that, my lord, that if someone has stood as a guarantor to me, and when I have taken any loan from the bank, that guarantee continues, even if it is for a period of 3 years. So according to me, my lord, only one substantial question of law, if your lordship pleases to frame, that will do the needful. And let them come, let them say, my lord, what they want to say upon this. Because the matter was entirely ex parte.
No, you come to paragraph number 14 of page number 25.
Yes, my lord. In the present case, the respondent defendant has not signed any such acknowledgement admitting his liability. Hence, the provision of section 18(1) of the Limitation Act is not applicable. Merely making a part payment of a time-barred debt cannot be considered as an acknowledgement under section 18 of the Limitation Act. This court is also not impressed with the argument that when part payment of time-barred debt is made, a fresh cause of action arises. The learned counsel for the appellant has failed to refer to any authority in this respect. My lord, when it is a continuing transaction, what authority is required, my lord? This itself is a perversity.
No, can you show any perversity in this observation made by the trial court? Or no, made by the first appellate court?
Yes, my lord, that itself, because the reason, my lord, it is an admitted position that the services rendered by me to the respondent company, my lord, was a continuing one. Today, a vehicle has got damage. They have stored to me. I have repaired it, and that much repairing amount I have credited to their account. Now, when it is getting credited, at one point of time they have come, and instead of paying, my lord, individually, that on that date, this was the amount, they have paid rupees 2 lakhs to me. Thereafter, my lord, 15,000 to me. Thereafter, 72,000 to me. And lastly, on 2/4/16, 3 lakhs to me. So the account itself is, my lord, continuing.
We'll fix it another date for further consideration. It is a well settled that this debt. When making part payment of time-barred debt, the limitation
No, my
cannot
lord,
be
No, my
extended.
lord, it is not a time-barred debt. It is a continuing debt. The learned trial court itself has said that it is a time-barred debt, but there is nothing before the learned trial court out of the 163 exhibits which I have produced.
Mr. Sutter, you see, this is concurrent finding of the two courts below.
Yes. But if I can show that perversity, my lord, before your lordship of the learned trial court as well as that of the first appellate court, though it is a concurrent finding, yet your lordship can interfere into that.
We'll fix another date for further hearing
Yes.
on this point. Heard Mr. Sutter, learned counsel for the appellant. Lays the matter on, Bobby.
On 8 or 11, 11.
11. For further hearing.
Yes, my lord.
Items for orders, item 27.
May be lost. My lord, can you see our mistakes, my lord? IA, my lord, 701. Your lordship on the last 23 has been pleased to accept the notice on respondent 7. So, my lord, as regards to service on respondent, here I beg to draw your lordship attention to another prayer, my lord. Another prayer, my lord, at page 6.
No, this IA is for what purpose?
My lord,
This IA is filed for what purpose?
701.
701.
709 for what purpose? I mean, you have stated that 709. 701, my lord. 70, my lord, my lord, can you see my prayer? Why? Here, one person, namely Begum Bahar, was wrongly treated, my lord. In the May, she was made a party. In fact, she died while during the pendency of the suit, my lord. Suit or lower appellate court. So her son, Shibul Ahmed, is very much on record, my lord. So my prayer is that in the name of the respondent, wrongly written, Begum Bahar's name may be deleted. In her place, her son, who is very much a party in the suit below, the Shabuddin may kindly be written, my lord. Office may be directed to write down his name.
Her son?
Her son, Shabul Ahmed.
Where it is mentioned?
Shabul Ahmed's name is in the original suit, my lord. Your lordship, the memo of appeal is required. Here, your lordship kindly see. If your lordship kindly takes up the memo of appeal, my lord, which is not yet registered because of the today's delay. Page 37 may kindly be seen, my lord.
No, first we have to dispose of this IA for
Yes, my lord.
condemnation
So
of
I
delay.
am to refer this name, my lord. Shibul Ahmed's name is in the original record. Just to show this one, my lord.
Where is that application?
Page 37 may kindly be seen. 701, this is listed.
আগে হেৰিটো হ'ব লাগিব নহয়, কণ্ডমিশ্যন হ'ব লাগিব নহয়, তাৰপিছতহে বাকী।
Shabuddin is very much on record, my lord. So in this place, his mother, who is already dead, my lord, her name may be deleted. Begum Bahar in my
Yes, Mr. Soroli.
Yes, my lord, I have been served with IA number 1820, that is condemnation application.
Yes.
And I am appearing for respond number 1, 2, 4, and 5, my lord.
Do you have any objection in condoning delay of 2 days on?
No, 2 days I do not have any objection, my lord.
Okay.
Regarding this parties, my lord, other parties I do not have any instructions, and I can submit on them, on behalf of them also, my lord.
Today is related after your lordship's kindness, and your lordship may be pleased to see the grounds I have mentioned.
Yes.
The wrong calculation made in my
Mis-
chamber.
Because of
So, my lord,
miscalculation.
we ought to have filed in the 1/4/2017 instead of it was filed on the.
Okay,
office.
okay. Heard Mr. Rajbar Bhuiya, learned counsel for the applicant. Then Mr. M.A. Chaudhary, learned counsel for the
1, 2, 4, and 5, my lord.
respondent number 1, 2, 4, and 5. Office note dated 15/7/2024 indicates that no service report has been received in respect of respondent number 7 and 8 by the section till date. However, office note dated 21/10/2024 in IA number 701 of 2022 and the order dated 23rd/10/2024 indicates that respondent number 7 refused to receive notice for which void order dated 23rd/10/2024 it has been held that notice deemed to be served upon respondent number 7. And the order dated 9/8/2024 in the said IA number 701 of 2024 indicates that notice upon respondent number 8 has already been served. But the respondent number 8 remain unrepresented in both the IA. This interlocutory application is preferred by the applicant for condemnation of delay of 2 days in preferring connected civil revision, no, regular second appeal against the judgment and decree dated 15/12/2018 and 2/1/2019 respectively, passed by the learned civil judge Corrington's entitled appeal number 46 of 2018. Mr. Rajbar Bhuiya, learned counsel for the applicant, submits that the appeal could not be preferred in time because of, what is the reason?
Only, my lord, that is the wrong calculation of the limitation period, my lord. 2 days. It ought to have been filed on 1/4, my lord.
Submits that because of the wrong calculation of the period of limitation, the appeal could not be filed in time. And that
It was barred by 2
the
days.
delay is not intentional, rather it is circumstantial. And the same has been explained in paragraph number 2 of the application. Having heard the submission of learned, Mr. Chaudhary, learned counsel for the respondent number so-and-so, submits that he has no objection in the event of condoning the delay of 2 days in filing the connected regular second appeal. Having heard the submission of learned advocates about the parties, I have gone through the petition and the documents placed on the record and the statement and averment made in the paragraph number 2 of the petition. It appears that the delay of 2 days has been sufficiently explained, and therefore this court is inclined to condone the delay of 2 days in filing the connected civil revision, no, connected regular second appeal. In terms of above this, IA 1820 stands disposal. Yes, Mr. Sodore,
Yes, my lord.
the 701.
701, my lord, I have not been served with a copy.
Yes.
I have this, and I was only, my lord, I have only filed.
Okay,
wakalat of
in
my-
view of the order passed in the IA number so and so, now the registry will proceed to register the second appeal and list the same before the court. In IA number 701, you take down. Heard Mr. Rajbaroya, learned counsel for the applicant, and Mr. Sodore, learned counsel for the respondent number so and so. Mr. Sodore submits that he has not been furnished with a copy of this petition. Accordingly, it is provided that Mr. Rajbaroya, learned counsel for the applicant, shall furnish a copy of the petition to Mr. Sodore during the course of the day, today itself.
Yes, ma'am.
List along with RSA number so and so. RSA.
Item 28. So appeal may be posted for admission for.
Registry will register and list
Yes.
it before this court.
Much obliged. 28.
My lord, it was kindly see it, IA 3437. Here, actually, I filed a petition of substitution of the legal representative of the appellant number 26. There is actually no delay. So, my lord, that may be, and that is why in that petition, I filed two applications, one for abatement and condemnation. But subsequently, I withdrawn the condemnation petition also on the before the registry. That is why, because there is no delay, I found now second that there is no delay. That is why condemnation petition has been withdrawn.
Yes, Mr. Ghosh.
26.
Okay, okay. Heard Mr. Ahmed, learned counsel for the applicant. Then Mr. S.K. Ghosh, learned counsel for the respondent number. One. Respondent number 1.
One of the former defendant, their name has been, they are not appeared, and some of them have been struck out, my lord. They are also not contesting the case before the court will be as well as appellate court.
This interlocutory application under Order 22 Rule 4 of the CPC is preferred by the applicant for substituting the legal representative of appellant number 26. Mr. Ahmed, learned counsel for the applicant, submits that respondent number, no, appellant number 26 suffered demise when?
On 16 to 2021.
On 16 to
2021.
2021. And as such, the legal representative of appellant number 26 may be substituted in the RSA number 8377
I have
of
the filing number.
2019.
How is the filing number?
This is filing number.
Filing number.
RSA has not yet been admitted.
Yes, no. Delay is not confirmed. I will come.
Mr. Ghosh, learned counsel for the respondent number 1, submits that he has no objection in the event of substituting the representative of appellant number 26. Having heard the submission of learned counsel for both the parties, I have gone through the petition and the documents placed on record, and I find sufficient ground for permitting the applicant to substitute the legal representative of the appellant number 26 in the connected RSA. Accordingly, this IA stands allowed. The name of legal representative may be substituted in the in the connected RSA,
As well as,
filing number 8377 of 2019,
as well as the condemnation petition.
and also in the condemnation petition.
As appellant number 26A to 26E.
Appellant number 26A to 26E.
So, my lord, IA 612, I do not want to place it, and the name of the appellant number 24 may be strike out. Appellant number 24.
You don't want to press this application?
Yes, ma'am. Because otherwise, matter is going to be delayed.
Heard Mr.
One minute.
Jayamel, learned counsel for the applicant.
Now, the name of the appellant number 24 may be strike out.
This application under order 22, rule 9 of the CPC preferred by the applicant for setting aside the abatement of the appeal against appellant number 2024. No, appellant number 24. Mr. Ahmed submits that he is not willing to press this application and the name of appellant number 24 may be struck off from the array of the RSA.
Well,
Filing number 8377 of 2019. In terms of above this,
My lord, maintainability. I'll raise the maintainability. Because appellant number 24.
pardon?
Appellant number 24's name has been struck off. So I'll raise the maintainability at the time of admission.
Maintainability of the
appeal.
appeal.
My lord, there are several appellants. One person can file an appeal, my lord. Not necessary to file every person.
No, it is not a.
My lord, it is
At the time of.
Then, my lord, the lordship kindly see.
In terms of above this,
Maintainability will be kept
this will-
open.
No, it is not, appeal is not come here. The lordship kindly say now, condemnation petition, my lord. Okay. 3568, my lord.
No, condemnation petition we will take it up
No,
only
that is
when the
No,
name of the this legal representative of appellant number 26 are to be substituted.
So after 10 or 10 days, matter will
No, immediately after this correction, the rest will list the
Okay.
matter before
My
the.
lord, I'm telling my lord, after all the respondent, necessary memorandum is to be submitted, my lord. First
Amended memo of appeal.
Yes.
Yes. The learned counsel for the appellant shall furnish. No, submit the. No, file the amended memo of appeal.
After deletion of the name of all.
Yes,
Item 29.
after deletion of the name of respondent number 24, and after substituting the legal representative of respondent number appellant number 26.
My lord, other respondent's name has also been strike off.
My lord,
Not only
let the
one-
come, my lord, there, lordship kindly say whatever.
All the performer
They have
respondent's
filed-
name has been struck
My
off.
lord, no, my lord.
I am only for the respondent number 1.
It is, my lord, lordship kindly, they file a suit. In the death suit, they strike out the name of all the respondents.
I am
And
not
even
raising
my lord,
objection.
even my lord, my lord.
I am not raising any
my lord,
objection, my lord. I am
even-
rather
even-
supporting his.
No, I am not strike of their name because they, I sub notice, they are not prepared.
Okay, at the time of admission
Yes,
of the
my lord, it
RSA,
will
we
be
will
considered.
hear the matter.
Yes.
29.
Please, Your Worship.
Yes,
Worship, I have taken the steps on the last occasion, honorable court has directed me to take steps, and I have taken step on 7th of October 2024, Worship, and the published report has not come yet.
Office note dated. Heard, Mr. Your good name?
M.H. Ali, Lordship.
Learned counsel for the
Appellant, Lordship. Appellant petitioner, Lordship.
now order is being passed in IA.
Lordship. Petition.
Office note dated 21/10/2024 indicates that service report upon respondent number 1A to 1D are awaited. List the matter after 2 weeks awaiting service report upon the respondent number 1A to 1D.
Lordship, there is another IA 715/23, Lordship. Lordship, this IA is filed for the strike off of the name of the respondent number 6, Lordship. She died unmarried, Lordship. Therefore, her name may be strike off, Lordship. Respondent number 6 expired on 5/3/2020, Lordship.
So let the other side appear, we will consider your prayer.
Lordship.
And the appeal has not yet been admitted.
Lordship.
Heard, Mr.
M.H. Ali.
Learned counsel for the applicant. This application under Order 22, Rule 4A of the Code of Civil Procedure is prepared by the applicant. 4. Deleting the name of respondent number
6.
striking out the name of respondent number 6 from the array of the RSA, connected RSA. This you have given the number, RSA number, it is filing number or it is a regular number?
Lordship, IA civil number 715
RSA.
is the registration number.
RSA was admitted or not?
RSA is Lordship 114.
Admitted.
Admitted, Lordship. 114.
Acha.
It's a 2016 matter, Lordship.
Going for the respondent. None of this. The learned counsel for the applicant submits that during the pendency of this RSN number 114 of 2016, the respondent number 6 suffered demise. And as such, the name of respondent number 6 may be struck off from the array of the RSN number so and so and so. Where is the death certificate?
Lordship, it's a death certificate is not annexed, Lordship. The respondent has informed us the date, Lordship, on 5th of March 2020, Lordship. He expired.
5th of March
2020, Lordship. Lordship, may find it on page number 7, Lordship, of the IA 715. There are number 3, Lordship.
Yeah. Counsel for the submit that during pendency of IBC number 6 offer demand and such the name of number 6 may be struck off from the error correspondence in the output.
The learned counsel for the applicant submits that the respondent number
6,
respondent number 6 died on 5/3/2020. Leaving no legal representative for substitution. and therefore it is contented to allow the application. But having heard the submission of learned counsel for the applicant, I have carefully gone through the petition and the documents plus on record. Gone through the petition. It appears from the averment made in the paragraph number 3 that the respondent number 6, Angurmai Begum Majumdar, expired on 5/3/2020. And she was unmarried and she left behind no legal representative for substitution. Accordingly, this application stands allowed. The name of respondent number 6 may be struck upon the array of the RSN number so and so, so and so. The counsel for the appellant shall file amended memo of appeal. Cost settle file করলে হবে না? Amended cost settle. Amended cost settle. Within a period of 2 weeks from today.
Item 30.
May I please, Lordship? Lordship, as here has come, we have taken step towards your procedural. Lordship, service has not completed. Service has not completed.
Where is the service report? On what basis you were submitting that the service completed? Heard, Mr.
Hussain.
Learned counsel for the appellant. Office note dated 2/9/2024 indicates that the LCR has been received. But the said office note is silent in respect of service of notice upon the respondent. Order dated 28/8/2024 indicates that the learned counsel for the appellant submits that he will take step upon the respondent by usual process. But there is no office note in respect of taking step by the respondent by the learned counsel for the appellant upon the respondent. In view of above, it is provided that learned counsel for the applicant, the appellant shall take step upon the respondent person to order dated 28/8/2024. List after 4 weeks.
32.
May it please the Lordship. My lord, in this matter, my lord, on the earlier date, my lord, the respondents had informed that respondent number 3 had died. So, my lord, we need some more time to collect the names of the legal heirs of the respondent number 3, my lord, for substitution, my lord.
Heard Mr. S. Das, learned counsel for the applicant, and Mr. Ajay Ahmed, learned counsel for the respondent. Respondent number
1, 2, and
1, 2, 4, and 5. Mr. Das submits that during pendency of the RSN number 74 of 2024, respondent number 3 suffered demise, and he may be granted some time to collect the details of respondent number 3 so as to implement the legal heirs in the RSA number 74 of 2024. Here is accordingly allowed.
After 2 weeks, maybe?
List the matter after 2 weeks.
No.
This will also file as well as item 24, my lord. Here also separate substantial question of law file. And
But in the
this-
connected
and
memo
this could consider.
33 and 34. My lord, both the matters relating to same, out of the same cause of action, parties are same. And in first item 34 FAO, we have filed an affidavit in opposition enclosing some documents. Today we have filed, my lord. So our affidavit may be taken up along with the main records, my lord. Today is also time is any day in the next week, my lord.
Okay, Lordship, and stay in the IMA, the continuing Lordship, in IA civil number 2213 of 2024. There is a stay
Third
order.
Miss R. Saha, learned counsel for the applicant, and Mr. Sigdar, learned counsel for the respondent. Mr. Sigdar submits that he has filed an objection petition enclosing some documents, and the same is not placed on record. And accordingly, Mr. Sigdar submits that the matter may be listed on any other date in the next week. Here is accordingly allowed. Justice shall list the matter on 8. Till then, interim order passed in IA civil number 2213 of 2024 shall continue.
And in the meantime, if they would desires to file any rejoinder to our.
That is their prerogative. We cannot direct them.
My lord. 37 and 38.
No, I'm for respondent also.
None appears for the appellant on call. However, Mr. is a secure learned counsel for the respondent present. List the matter after 2 weeks.
Item 36 for hearing.
In this case, time it was listed, Lordship directed the government advocate, Mr. Gogoi, to bring in some report. Lordship.
Yes.
Lordship, we have received the report from the Hazo police station. Okay.
Yes.
So that police case has already been disposed of after trial. So we'll call for the record from the trial court. Jam first class Hazo. Third Miss R.D. Mazumdar, learned counsel for the appellant, and Mr. K.K. Dotto, learned counsel for the respondent number 1 to 3. And Mr. Gogoi, learned counsel for the respondent number.
One, two, three.
For the newly implemented respondent number
5.
5. Person to direction of this court dated 22/10/2024. Mr. Gogoi has obtained necessary instruction and placed the same before this court, and perusal of the same indicates that Hazu PS case number 289 of 2007 corresponding to ZR case number 368 of 2007 was surcited by surcit number 177 of 2009 dated 30th/11/2009 under section 279 337 338 304 put in bracket capital A IPC, and subsequently the case was disposed of by the learned trial court by judgment and order dated 17/8/2012, and the accused was acquitted. In view of the grievance raised in this appeal, perusal of the aforementioned record of ZR case number 368 of 2007 is found to be necessary, and accordingly it is provided that registry shall call for the record of ZR case number 368 of 2007, which has already been disposed of by the learned Judicial Magistrate First Class Hazo by judgment and order dated 17/8/2012. List the matter after 2 weeks. After 2 weeks. The documents placed before this court by Mr. Gogoi shall be part of the record. Yes. Pardon? Pardon?
December, Lordship, 3rd December.
2 weeks तक है भाई December को.
What date are the delay?
Last week of November, okay, 28.
28th.
28 November.
तब के 3rd ही भाग दिया. Third is convenient.
3rd of December.
December. Because 2nd is holiday, we can go.
Okay.
That's what I like.